Hello. Whoops. Hi. Can you guys hear me okay? It's a little difficult for me to tell. Oopsie. I knew that was going to happen. Sorry. Let's not just dance. How is everybody? I hope I am not unclear. I'm here, but we'll be decorating. Oh, Val. It'll be adorable. Oh, good. I'm so glad. Okay, because I'm in a different room. Wonderful. Hi, good morning, Oomph. How are you? All righty. Well, I thought I'd give you a different view this morning. And the cats are far more camera ready than I am. No, actually, I'm fine. But I just thought, oh, well, it's a nice kind of cloudy, cool day here in Los Angeles. And I thought, wow, I really like that. I like the sky. I know I'm sure it's not doing it justice, but regardless, I'm telling you, it's a nice sky today. Fluffy gray lined clouds and little patches of blue peeking through. It's really quite nice. So, well, welcome to Literally with Lolo. Saw this document. Actually, I think it was a Midas touch. Midas touch. I think it was a Midas touch thing that I saw regarding this motion to dismiss, and that and I don't understand all of this, so I apologize for not paraphrasing it properly, but there was something relative to the fact that this allowed, and that the intention of the motion was to get discovery. And that's what Abbe Lowell's, according to pundits far smarter than I, that is what Abbe Lowell is trying to accomplish, which makes sense. At the risk of empowering a story about Hunter's dick, I wanted to kind of, it's a long document, so I don't know it to the point where we can really get through it, but I'd kind of like to try to get through some of it, but I may need to take some breaks because my voice is coming back, but it's not like, it's probably like 89%. So I need to take care of it, and I need to get rid of all the mucus inside of my body, which I understand is way too much information. Okay. Sounds good, Jim. Take care, okay? I hope everything goes well. I can't wait till she's straight. Oh, I'm sorry. Yeah, that's a tough phase. I wish you the very, very best. The very, very best. And really, best regards to your wife and her mother. And I'm just so I'm sorry you're going through it, but boy, it's so nice that you're so there and with her. So I think that's lovely. That's a lovely thing. People are people, and deserve that. All right. So I have a couple. First, let me tell you what I have in store for you. First, what I want to do is, when a few more people get in here, play the video that Oomph asked if I would make a video to accompany his amazing song about Rudy Giuliani. Brother, can you spare some? And so I was honored to make that video and contribute to the project. And it's a great song and a great recording. And he's a really good musician. And I'm really happy that I love the creation. I love creative people, and he is definitely a creative person. Okay, let me go ahead and actually pull that up. I'll play it a couple times, but let me go ahead and play it first, and then we'll do that. And I'm sorry, my replay of it, I'm sure doesn't do it justice. So please, I'll put the link in. Please watch it on your own, and then we'll do that. Okay, hold on. Let me turn it all the way up. All right. Here we go. Oomph Cavalrest presents an Oompflow production. Are you kidding? Sorry.
I was a New York, U.S. attorney, fighting organized crime. Now I'm a Roger Stone type fixer. How hard could it be? Brother, can you spare a dime? Once when I was mayor, 911, I preened on all the nation's TVs. Now I spend my time in court, getting done. Brother, can you pay my legal fees? Once with heads of state, bravely in crises, were fettered with the president's friends.
Stupid, dumb.
Gambled their licenses. I was the one in defense. Say, won't you believe me? I have the proof. You can count on guys like me, always. Tune into my podcast, you'll see it soon. Tell them, brother, can you spare $148 million?
Brilliant. That was so good. I love that song. You did the thank you for doing the subtitles. That's perfect. Oh, that's great. Well done, sir. Well done. So that is the amazing new hit, A Big Drop by the man himself, the man, the myth, the legend, the enigma, the paradox, the burrito wrapped in a paradox of enigmas, all of those things. So yeah, that's the hapsy paps on all of that. But let me go ahead and what we're gonna do today. Oh, actually, hold on. I'm gonna take a little bit of a break. I just need to talk to Bobo. Hold on just a moment. Okay, I'm back. Here we go. Here we go. I can't get the camera to really get the sky. I'm really sorry about that because the sky is really cool. Okay. So I have two. Well, I think what I do have the original Hunter indictment, but I don't think we need to go through that. I think what is better, well, I think the first thing we could start with is actually what drew me to this document. And it was Empty Wheels post. Well, it was this post on Blue Sky because now I'm like addicted to Blue Sky. Anyway, so it's this is the blah, 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 blah. Hearing footsteps, a paper trail of political interference David Weiss is trying to bury. So this is the link that she puts in. And as I was reading this, I was like, oh, this is very interesting. Abbe Lowell's motion to dismiss the gun charges against Hunter for selective and vindictive prosecution and violation of separation of powers only asks for discovery in passing. Often, MTDs for selective prosecution are requests for discovery. For comparison, in a bid to argue that Jan 6er David Judge was charged more harshly than Portland rioters, his excellent public defender, Elizabeth Mullen, conceded that she did not yet have proof he was treated worse because he was a Trump supporter, but then asked for 6 specific things to prove the case. And as they go down through this, it's any communications that might exist between the DOJ, U.S. Attorney, etc., all of this. Mullen's bid didn't work. Judge McFadden ruled that January 6th was different than Portland, though he did use her argument to treat Jan 6ers leniently at sentencing, which I also thought was interesting. Oh, whoops, where's my phone? Oh, are you kidding? The one thing I forgot is my phone. Boo, boo, boo. Really? Oh, man. All right, hold on just a second. BRB. BRB, BRB, BRB. Okay. Sorry. All right, hold on. Let me turn this down so that I can just. Sorry. Okay, sorry. Let's see here. Meep, mop, moop. Meep, mop, moop. Hey, wait a minute, Mr. Postman. Ooh, what? That was quite a little jump. Okay, here we go. Oh, wait, sorry. Let me go back to that. Okay, so Lowell closes the brief. Okay, so compare that statement with this one from page 50 of Abbe Lowell's 60-page selective and vindictive MTD, where he asserts that this is the exceptional case where a defendant can prove vindictive prosecution without discovery. Cases where a defendant can show actual vindictiveness without discovery may be few and far between, but this is surely one. Lowell closes the entire brief with a similar statement, footnoted with the assertion that, quote, were there to be any doubt at all, the basis for discovery in any evidentiary hearing has been well established. Did I read that wrong? Quote, our society is not bettered by law enforcement that is not conducted in a spirit of fairness or good faith. Banks, blah, blah, blah. This prosecution falls in that category, and the court should dismiss the indictment. As stated through this and other motions to dismiss, the record available to the court supporting dismissal is extraordinary. Were there to be any doubt at all, as the basis for discovery and an evidentiary hearing has been well established. Okay. This argument that if Hunter Biden hasn't met his burden for outright dismissal, then surely he should be granted discovery, is 4 other times relegated to a footnote. One such footnote appears in a passage purporting to lay out the legal standards that govern this issue, in which Lowell cites, maybe I'll make it a little bigger, in which Lowell cites a bunch of precedents from other circuits about dismissal in a case of selective, vindictive, or separation of powers violations. Quoted section, when a prosecution is selective, vindictive, or violates separation of powers, the tainted charges must be dismissed. Further quote, preservation of the system of checks and balances requires the courts to invalidate actions that undermine the authority and independence of one or another coordinate branch. In Aiken County, quote, If the executive selectively prosecutes someone based on impermissible considerations, the equal protection remedy is to dismiss the prosecution. Where a defendant has not carried, and this is the footnote, where a defendant has not carried his burden, but has demonstrated a, quote, colorable claim, discovery and an evidentiary hearing should be permitted. Heidecke, Jones, blah, blah, blah. Granting discovery to give the defendant, quote, the opportunity to move to dismiss the indictment for selective prosecution. And then this is his, what is that? MOT? Motion? Is that motion? Discovery motion? Okay. Armstrong, the precedent making it almost impossible for a defendant to get discovery, the one that Principal Senior Assistant Special Counsel Leo Wise cited 48 times in his bid to defeat subpoenas, does not appear in this section, though it does appear in several other places and in the discovery motion. As this footnote does, two other footnotes specifically cite a motion for discovery and evidentiary hearing filed the same day. In those two other two instances, Lowell cites the line in the NYT article describing that David Weiss told an associate that he preferred not to bring any charges because the average American would not be charged for these crimes. Whoa. The New York Times reported that, quote, Mr. Weiss told blah, 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 blah. Okay. Michael Schmidt, Inside the Collapse of Hunter Biden's Plea Deal, that's the article referenced. The article does not disclose the source. The account is most likely true, considering the charging statistics, DOJ enforcement policies described below, and Mr. Weiss's initial reluctance in prosecuting Mr. Biden on this charge. If it is true, it is extremely damning evidence of discriminatory prosecution. Thus, to the extent there is any doubt, the court should grant Mr. Biden's request for discovery, blah, blah, blah. DOJ confirmed in its own improper motive when, under fire from Congress and the public, it resorted to a rarely used gun charge that reports indicate Special Counsel Weiss himself admitted would not have been brought against the average American. As noted above, the article does not disclose the source, and to the extent there is any doubt about the veracity of the claim, the court should grant Mr. Biden's request. I have repeatedly predicted we'd see this language in Hunter's selective prosecution motion because it provides what virtually no defendant ever has, proof that the prosecutor himself recognized that he was selectively prosecuting a defendant. Wow. If Lowell can find these witnesses, experts on gun crimes, who said Hunter was charged only because he was a prominent and a Weiss associate, whom Weiss purportedly told he knew that average Americans would not be prosecuted for such crimes, and get them to testify, then he would have what virtually no other defendant would, proof that okay, blah, 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 blah. But I assume the proof that David Weiss had said that David Weiss had said that would require witness testimony. Perhaps it doesn't. Consider that the last instance in this filing where Lowell relegates a request for discovery in an evidentiary hearing to a footnote, he makes an assertion that DOJ has long believed that Hunter's rights must take precedence over efforts by Trump to interfere in this prosecution, that he does not cite. Another quoted section, but as DOJ itself has long believed, Mr. Biden's rights must come first, and efforts by members of Congress and the former president to interfere have tainted this prosecution beyond purification. As a result, there is no constitutional option but to dismiss this case. Footnote. If the court has any doubt that the material set out in this motion is sufficient to warrant outright dismissal of these charges, it should permit discovery and conduct an evidentiary hearing. Mr. Biden has already sought discovery from DOJ and information from third parties with knowledge of former President Trump's influence, and DOJ has not responded to the requests and filed an opposition for this information to be disclosed. To be sure, we know that David Weiss's investigative team, led by Leslie Wolf, made repeated efforts, not always successful, to shield the investigative team from Trump's efforts to interfere. For example, Tim Tebow told the House Judiciary Committee that the one reason he shut down Peter Schweitzer as a source was because then Supervisory Special Agent Joe Gordon reached out, insinuating they already had laptop-based evidence, and said that if a case against Hunter Biden ever went to trial, and Hunter's attorneys found the FD 1023 from Schweitzer that the Washington field office had shared with the Hunter team, it would give Hunter's attorneys ammunition. So this is a transcript, Tim Tebow's transcript answer. And then fast forward to sometime in October, I received an unsolicited call from the supervisor of the Hunter Biden case. I knew him because he had been assigned to the Washington field office as the case agent. And I said, okay, what are your concerns? And basically said, look, the information isn't of any value to us. Number one, I deduced from everything he said that they already had the information from some other source, some other channel, maybe not a human source, okay, but some other channel. He also said that that person was politically connected. Are we talking aliens here? Are we talking UAPs right now? And partisan in his view, and he was concerned about the source being on media platforms. Oh, so I was getting a call from this supervisor, and my takeaway was, we don't need your source reporting, and also, why are you sending a file to our case file that we didn't know about, right? So Washington field office wrote this 1023, and it went to headquarters, and it went to Baltimore. And I understand you don't need the reporting anymore. I understand that if this goes to trial, Hunter Biden's attorney could have some ammunition. Regarding that very same laptop, Gary Shapley complained to Congress that Weiss's office had prevented Joseph Ziegler from seeing a report addressing the quality and completeness of image recovered information from the hard drive. I'm fascinated by this because I think it was such an obvious manipulation. I can't wait till we get more. This is the Shapley email about quality and completeness of image recovered information from the hard drive. SA said he had not seen it. U.S. Attorney's Office said that he would not have seen it because, for a variety of reasons, they thought they needed to keep it from the agents. They were going to give a redacted version at some point to the agents. Stefania takes what comes from Dylan. Okay. Ziegler himself complained that he hadn't been able to interview Tony Bobulinski, the guy whom Donald Trump personally hosted at an election debate and who subsequently had a clandestine meeting with Trump's chief of staff because prosecutors told him Bobulinski, quote, was not viewed as a credible witness. Yeah, nothing that he says lines up with actual documented events. Quoted section. In investigative team meetings that occurred after this, I can recall that agents on the investigative team brought up on multiple occasions to the assigned prosecutors that they wanted to do an interview of Bobulinski with the assigned case agents. I can recall being told that they would think about it, and then ultimately being told there was no need for the team to interview Bobulinski, and Bobulinski was not viewed as credible. And Scott Brady not only confirmed Gary Shapley's claim that Leslie Wolf repeatedly refused to be briefed by Scott Brady's team because she didn't want dirt from Rudy Giuliani. Oh, Rudy Giuliani sticks his dick in everything. But also that David Weiss had to, and did, intervene before Wolf would share information about her investigation with Brady. Quoted section. Okay, so looking at paragraph 4 on page 2, as it continues on to page 2, second full sentence, it says, the prosecution team discussed the Hunter Biden related work of the Pittsburgh USAO on several occasions, as it was a line item on the recurring prosecution team's call agenda for a long period of time. Assistant U.S. Attorney Leslie Wolf told us the Pittsburgh USAO and U.S. Attorney Scott Brady requested to brief the Delaware USAO's Hunter Biden's investigative team on multiple occasions, but they were turned down by AUSA Wolf and the Delaware USAO. Is it accurate that you had requested multiple times, you or your office, to brief the Delaware U.S. Attorney's Office? Yes. Answer, yes. Chairman Jordan, got it. Now, also, well, this is Jimmy Jordan. Okay. Okay, let's rephrase this. Chairman Jordan. Got it. Now, also, based on what you said throughout the process, you said that the Delaware Attorney's Office wasn't willing to cooperate so much that you had to send in interrogatories? Mr. Brady. Yes, we had conversations, asked for communication and a flow of information, mostly one way from us to them. But also, as I testified, we wanted to make sure we weren't duplicating what they were doing. They would not engage. So finally, after me calling Mr. Weiss and saying, can you please talk to your team? This is important. This is why we want to interact with them. The response that we got back is, you can submit your questions to our team in written form, which we did. This is an important instance where, at least per Scott Brady, Leslie Wolf was attempting to prevent the politicization of the case, but David Weiss overruled her. Finally, Shapley also provided documentation of his own complaint that this investigation has been hampered and artificially slowed by various claims of potential election meddling. There are abundant examples where Leslie Wolf attempted to shield the investigative team from Trump's efforts to intervene. Lowell cites none of them, nor other public evidence, such as Ziegler's testimony that there were emails, probably his original supervisor's memorialization of Trump's improper influence. Instead, he asserts without citation that DOJ has long believed that Hunter's rights must come first. I'm mindful that in the exhibits that accompany the motion to dismiss because the diversion immunizes Hunter Biden from further charges, Lowell also didn't include the bulk of documentation that NYT, the New York Times, and Politico appeared to have relied on for stories about how the plea deal collapsed. That is, it's possible that one of the documents that NYT received records someone, possibly Wolf, sharing with Chris Clark the explanation that Weiss really wanted to avoid any charges, even misdemeanors. If Abbe Lowell has that document, he's playing coy. Indeed, that's an important dynamic in the motion for discovery and evidentiary hearing. In a footnote 6 in this post, it purports to support both the selective and vindictive motion and the immunity one. To the extent this quoted section, to the extent the special counsel disputes the facts laid out in Mr. Biden's motion to dismiss the indictment based on immunity conferred by his diversion agreement and the declaration of Christopher Clark, his former counsel, filed contemporaneously, as noted in that motion at Note 1, an evidentiary hearing where all the participants to the negotiations, including U.S. Attorney David Weiss, should be held on that motion as well. The footnote it cites in the immunity motion, footnote 7, asks Judge Mary Ann Noreika if she needs more proof regarding the immunity conferred by the diversion agreement to include David Weiss and responsible members of his prosecution team, which would include Wolf, among the witnesses. Is that right? Peril evidence? Proof. So that's peril. Mr. Biden requests an evidentiary hearing in which all participants. Okay. Even in the discovery motion, Lowell doesn't provide a list of things like the one that David Judd's attorney included in hers. Instead, he simply points to the October 8th and November 15th discovery requests he already made and describes that Weiss' team responded with silence. On October 8th and November 15th, as well in follow-up correspondence on November 15th, Mr. Biden wrote to the prosecution team with tailored and enumerated discovery requests, many of which are routine in a criminal defense case such as this one. The October 8 requests included customary Rule 16 discovery requests and 19 specific requests under the Brady, Aggers, Giglio, and the Fifth Amendment. Rule 26, Jenks Act, and similar requests. I'm going to take a drink. Hold on. I'm getting a little gravelly. Oh my gosh. Look at that view. Can we just look at that view for a moment? Actually, let me show you this view. Let's see what happens when I do this. There you go. I know it's too tiny. You can't read the thing. But look at it. Oh, it's so chill. There's no cats in there. I don't know where they are. Okay. Sorry. Let's go back. Let's go back to Jurassic Park. Well, that's still hard for you guys to read, but I know you can do it. I believe. I believe my children are the future. Every few hundred millennia, evolution leaps forward. So true, Tom. So true. So true. I mean, I guess, isn't that kind of like a inevitable? I mean, that feels like a feature, not a bug. Okay. All documents and records reflecting communications from January 20th, 2017 to the present, the relevant time period, to, from, between, or among Donald J. Trump, William Barr, Jeffrey Berman, sorry, I always do that, Scott Brady, Richard Donahue, or Jeffrey Rosen, relating to or discussing any formal or informal investigation or prosecution of Hunter Biden or a request thereof. Number 2. All documents and records reflecting communications from the relevant time period to, from, between, or among Donald J. Trump, William Barr, Jeffrey Berman, Scott Brady, Richard Donahue, or Jeffrey Rosen, and any executive branch official, a political appointee,
Department of Justice official, government agency, government official or staff person, cabinet member, attorney for President Trump, personal or other, discussing or concerning Hunter Biden. Let's see. Where's Steve Bannon fall in that? We are that evolution, Lolo. Yeah, well, let's hope. Jeez. Jeez. I don't know. Man, I'm feeling like you get slammed for being, I don't know, nice. I'm not sure. Well, no. I know my those who don't like me don't think I'm nice, but I have no idea why. Okay, let's see. There was SDNY investigated both Hunter and James Biden as part of their investigation into Patrick Ho and Gal Luft. So there may be communications between Berman and Weiss on that topic. Berman's investigation of Lev Parnas would have covered the October 29 meeting. Oh, tell me about it, kid. Would have covered the October 2019 meeting at which Parnas believed he received laptop-based dirt from Burisma associate. Plus, Berman would have been told to stand down on Rudy Giuliani's December 5th, 2019 meeting with Andre Durkach. I don't know how to say that. If they wrote it in Cyrillic, it would be easier for me to pronounce. I know that's dumb, but there's my brain. In deference to Richard Donahue, his book describes that those discussions were quite heated. Is that Richard Donahue's book? Wait, whose book is that? Whose book is that? Who wrote a book? Okay. The October 8th request is, as Lowell claims, more conventional, at least on its face. It asks for the evidence Weiss has about Hunter's addiction. It asks for affidavits in support of warrants. And some of that, a request for communications on the drafting of the plea agreement, and stats on prosecutions of these gun charges, definitely would support Lowe's motion to dismiss. There are unsurprising additions, such as any communications regarding leaks to the press, including through cutouts, which is how I think the October 6, 2022 leak happened. From the motion to dismiss, any documents and or information reflecting communications between anyone in your office or any member of the investigative team and their supervisors, including the FBI and IRS agents, with any member of the press or public concerning the investigation, and any documents and or information reflecting leaks of information concerning the investigation or prosecution of Mr. Biden to the press, any private person or any government official or employee who was not authorized to receive such disclosure. Well, say what you want, but that LSD didn't impact Abbe Lowell's ability to probably delegate writing this to someone else, but whatever. No hate here. Sure, this likely aims to discover whether Shapley and Ziegler had any role, including through cutouts, in the leaks in the case. But as I noted in my post on that New York Times story, there are several claims in it attributed to a, quote, senior law enforcement official with knowledge of the situation, who claimed to have knowledge of things only David Weiss would know. Then there are things that look innocuous, but might be particularly problematic for Weiss. Given my suggestion above that there may be documentation of a claim that Weiss told an associate he didn't want to charge Hunter at all, a collection of all the communications anyone in his office had with lawyers for Hunter might pose hazards for this prosecution. From the MTD, any documents and/or information reflecting communications between anyone in your office and any attorney representing Mr. Biden from the onset of this investigation to June 20th. Oops. Normally, when someone takes over a case from a prior defense attorney, they usually get a case file from their predecessor. Lowell would be expected to ask Clark for this, but there are at least two other sets of lawyers who would have been involved, including an investigative interview with George Maziris, I'm not sure how to say that, which would justify this request. Complying with this request would involve Principal Senior Assistant Special Counsel Leo Wise seeing communications that David Weiss may have attempted to use him to sheep dip from the prosecution. Then there's a request for 302s. Any draft FBI 302s, FD 1023s, or interview memoranda describing such interviews. Any requests by investigating agents or members of Department of Justice to edit, revise, or otherwise change the content of any 302 or interview memorandum. This would include the FD 23s from Peter Schweitzer and the Slufchevsky informant, the 302 from Luft, as well as the draft 302 from Tony Bobolinsky, and any record that DOJ interviewed to prevent its completion, at least 3 of which Wolf attempted to keep from investigators. Weiss may be imagining he can withhold these based on a claim that the gun. Hey, Paul, how are you? Based on a claim that the gun charge doesn't implicate these documents pertaining to politicized witnesses, and normally he'd be right. Except Judge Noriega already permitted Jason Smith to file an amicus, including protected grand jury materials, based in part on the argument that this has gotten so much publicity already. Plus, in both Jack Smith's prosecution of the former president and the serial treatment of Mike Flynn, there is arguably support for sharing such information. I asked Weiss's Spox if his team, spokesperson, if his teams would adhere to the discovery approaches in those cases, and got no response whatsoever to my question. Finally, there are communications with Congress. Any documents and or information reflecting communications between any member of Congress, committee or subcommittee of Congress, or congressional staff, and any person at the U.S. Department of Justice, including your office, concerning the investigation of or prosecution of Mr. Biden, including the decision to bring any particular charges. The EU is investigating X. Oh, they don't fuck around. I remember trying to help a new nonprofit figure out their fundraising strategy for European donors, and it's not well, and it's not easy, and it's for good reason. I mean, it's fine. Let's see. Because people can't behave themselves. It would also include the transcripts. Oh, wait, here we go. This would include the letter that Chuck Grassley and Ron Johnson sent in 2021 regarding any gun charges against Hunter. It would include the many letters sent to Merrick Garland. It would also include the transcripts of the many interviews, including Brady Tebow from Leslie Wolf last week and from Weiss himself. Jim Jordan did. At least some of those were shared with DOJ for an accuracy review, and in Weiss's transcript, he made a claim that has already been rebutted in Chris Clark's declaration, in which he described Weiss's first AUSA, saying there was no ongoing investigation into Hunter Biden. This is an area where the Jack Smith precedent may be pertinent. In a response to Trump's demand to subpoena Congress, which Lowell doesn't do, Thomas Windham revealed that Smith shared 260 January 6 committee transcripts with Trump. Jim Jordan has spent 5 months quizzing almost every member of the Hunter Biden investigative team about whether there was political interference on this case, which seems to make it relevant for any litigation about Congress's usurpation of David Weiss's role. Normally, none of this would be discoverable, and Principal Senior Assistant Special Counsel Leo Wise is likely to come back and say it is Jenks, which will be relevant if these witnesses testify. As I keep saying, normally none of this goes anywhere. I am assuredly not saying this will work. What I'm trying to lay out is that Lowell is going about it via different tactics, in part by arguing this known proof of political interference is Brady about Brady, not just evidence of selective prosecution hidden behind 48 invocations of Armstrong. If Lowell prevails with his argument, his strongest argument, in my opinion, that Hunter is immune from prosecution on the gun charges, none of this may matter, until Lowell makes the same argument in Los Angeles before a different Trump-appointed judge. But once you get into the argument about improper influence on this case, David Weiss might begin to hear footsteps. Hey, that's excellent. Let me give you that. I'm going to put that link. Of course, Marcy, who goes by Empty Wheel, is like one of the most amazing people and commenters on the interwebs. So highly recommend following Marcy. Very much so. Very, very much so. Wherever you can. Get her wherever she is. Okay. All right. Okay, and we'll take a little break before we take a look at the document. I feel like putting on some music. Let me see what's going on with, you know what? Hold on. Hold on to your love. You got to hold on. Ooh. Oh, I know. I need to go somewhere else. Hold on. Beep, 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 beep. Wow, I'm actually in a really like I think it's the weather that is like it's a little gray and over. I just adore it. I'm loving it. I'm loving it. Oh, great. Thanks, Tom. Yeah, she's really good. Really good at what she does. Here we go. This is what I want. This is what I want. This is what I want. I want to do chill. Chill. Chill, chill, chill. Chill. All right. Oops. Oh, I see. I have to do that. What? That person's on there? Oh, wow. I did not realize. So cool. What? Let me try this one. Blue Dream. Oops. I don't know if I like that. Sounds like a song. Oh, kind of like, oh, I like this guy. Oh, God, I hate that song. Oops. I kind of like this. I'm going to turn it down a little bit, though. All right, I'm going to see what happens when and then what I can do is I can nope. Oh, I want to do that. There we go. I know. I heard Tony got a timeout. What did he get timed out for? How come the mortgage rates went down? Did the Fed lower rates? I didn't even pay attention to that. Did they though? Is the music distracting or is it okay? Oh. Ah. I need some. My lips. My lips are dry. What's going on? I'm so sorry. I'm making too much noise. I apologize. Okay, I'm good. Gotta put some lip stuff on my lips. Oh, the 10-year note is lower. Yeah. Okay. Mm-hmm. The bond market's down. The bond market's down. And I know what that means. The bond market's down. I never really understood fixed income products. I'm going to be honest with you. It reached the maximum of my math brain. I was a terrible fixed income broker. I didn't do fixed income, actually. I did stocks and options and shit like that. Mutual funds and crap like that. Options were fun. Those were fun trades. Shorts, those were fun trades. I liked watching some of the big trade. I used to help out on the big trader desk at the firm I worked at. More because I was a nice person and I was good with customers. Not so much. I wasn't the best broker. In fact, I had a customer say, "You are a terrible broker." And I said, you're not wrong. You're not wrong. But I will bend over backwards to make you happy. So he wasn't kidding, but he was kind of kidding. I left faith. I have not, I mean, I have a page on Facebook. I'm not like, whoa, that's intense, Tom. Yeah, I basically don't I don't do anything on Facebook. I mean, we're on Facebook right now, Facebook Live. You were a volunteer editor? Oh, wow. That's terrible. I mean, a terrible job. Oof. Oof. That's bad. Okay, I'm gonna get into this motion to dismiss, but I'm kind of enjoying this right now. I'm really if that's okay with you. I'm just having a really nice smoke. What's going on today? I haven't even. Oh, wait, I did check the news. What have I shared on Blue Sky? The thing about it is, Tom, I left Facebook when I had I had a lot of like friends from high school on Facebook, and I didn't really keep in touch after high school, except for this one group of friends that are really important. And then I started to see all these other people who were like totally like right-wing Trumper, like way saying the most horrible stuff about people and Democrats and LGBTQ and whatever else. Just as much bigotry and hate as they could muster. And I was like, wow, what happened to you? Like, these were like literal Trump train people. They would take their big truck with their big flags. They were one of those people, and they would go and gather every week with their big trucks. It's weird. I guess I have to find more music. Hold on. Why doesn't it just keep playing? I wonder if it could do like, I don't know. Oh, wait. I don't know. What's this one? Oh, here we go. Let's do this one. Oh, I like. Oh, that's that terrible song. I hate that song. Here we go. Oh, beautiful. Now we're talking. Bass bag. Oh, that's cool. That's cool. I say do it. If you do it, I am all for it. I just had to leave. It just wasn't. It wasn't working for me. On to hate Sadie. On to hate Sadie. I don't understand that. Help me. What's that? I know it's something. I'm trying to read it. It's true. Nothing else works the same. I know. I think it's funny. Oh, that's right. I never even thought about that. I never even thought about the whole your axle. Hey, if you're like don't hate Sadie, SATIE. I don't know. I'm getting a little high. It's very bad for bearings. I can imagine. I mean, that's a lot of like, you know how when something like when you have a plank across two sawhorses and it sags in the middle, right? Is that what am I picking up what you're putting down? Composer of music, you just called that song I hate. I don't like that song. I don't like that. Is that bad? It's just depressing. I don't know why. Sorry. I can appreciate the art of anything, but yeah, so Tom, isn't that like, you know, a sagging like you know what I mean. Oh. I'm touching something. What's happening here? Oh man, this is so chill. I love it. Can we just stay here all day? Oops. Shit. Can we just stay here all day? Is that okay? I guess not. I do have. Okay, wait. I need to. Okay, I'm gonna drink this coffee and I'm gonna get back to work here. I'm sorry. I'm having a little too much fun. I could literally leave this up all day with those cats. I might leave this up for a while, even after I finish reading. You know, I think I might do that. Oh, I like this song. Where is it? Kurt? That's weird. Don't show it again. How do I, what did it say? I cannot believe this. Oh, this song. I have this song and it gets me every time. So what do? You download it? YouTube audio license. I think that's great. Oh, sorry. I'm very satisfied. Look at me. I'm so satisfied. The only people that used to do that were people that couldn't afford the right wheel combination. We used to tell people that they had the wrong wheels on their vehicles. It's just stupid. I don't remember being told that. We usually put music behind podcasts, usually rap beats. Oh, that's cool. Yeah. Well, I just think it's nice to have a little chilling. Okay. Let me go ahead and turn the music off, and I'm going to take you back to a depressive state. So there. Let me see. Is this it? Yeah. Okay. Boop. And then let me go back. Let me go back to a little place that we used to know. Oh. Wait, maybe I'll do that. Okay. Alrighty, Aphrodite. Here we go. Hit that like button. Please share. Please share. Because I am not on Shitter anymore, so I need your help. I need your help to get to people on the Shitter. Thank you so much in advance. Remember, I was a street racer. That's right. God damn it, Tom. I keep forgetting that. That's right. That is so crazy. I think it's amazing, but it's crazy. All right. So this is the This is the document. You know what? Let me try and do this the right way. No. Really? Why are you not showing it? Oh, okay. Now you are. I see. Okay, well, we don't need that. Yeah. Okay, this is great. Okay. All right. Once I get my Z24 done. Yes. Yes. A Z24. That's so cool. I like those. My dad, because of one of my dad's like midlife crises was to get the same car that Jim Rockford had when he had to get a car, to my mother's great dismay, by the way. Um, so replacing the family car, he got a uh, a Thunderbird, a brown one, just like Jim Rockford. I shit you not. I loved it. My dad loved fucking fucking love that guy. Yeah. So we drove. Oh my god. I have good stories about that fucking car, but anyway, it's funny. My dad was crazy. Sweet, but crazy. All right. So this is the actual motion to dismiss, the MTD for those of you who know. Let's see. And I won't read the whole thing because it's like 70 pages, but let's see. I know his fist fighting. Oh, a Firebird. That's what it is. Sorry, a Firebird. Yes, it's a Firebird. I swear to God, I have pictures of it. It's the same fucking car. Probably not the same car because my dad would have bought the cheapest version, which is fine. I don't begrudge him that. I think that's smart. Okay, here we go. It was an Esprit. I had a Formula and a Trans Am. Whoa, you are like into that. My favorite car of all time, which I never owned, is the GTO. Like a GTO would be a dream car for me, even though I realize it's terrible for the environment. I'm just saying. That to me is I love cars. I actually love architecture and cars. So I'm good with that. Okay. So this stuff gives factual background, legal standards, and the argument. Okay, so let's see. Table of authorities. So all the citations and the pages they appear on. Well, let's hope there's 10,000 pages of citations, children, because then there's less for us to read. Oh, damn. Oh, damn. Okay. All right, file 1211 23, page 8 of 69. Oh, 69. Do you think that was on purpose? I'm kidding. I kid. I kid. I kid. I kid. All right, one more drink. Oh, you know what? I'm going to pee before I do this because I want to like try and be like here. I'll BRB. You had a chance to get a GTO. The guy was a hoarder and wouldn't. A 1970 GTO. Oh my god. Oh my god. What color was it? Oh. I mean, if I ever like win the lottery, I might indulge. I mean, other than like starting a foundation and helping people, I might get it myself a GTO just for fun. Hey, Rogue, how are you? Lester Ripley, Rogue Etiquette. He had a mint triple black. Oh, a Chevelle. Those are so cute. Okay, literally, Okay, I'm back. All right. Okay. All right. Okay. Let's go back to Jurassic Park to vindictive prosecution. Mr. Hunter Biden's penis. It's really naughty. Yeah. Okay. This indictment reflects a selective and vindictive prosecution of Mr. Biden, I might burp, and a breach of separation of powers. And it that is that right? And that. Oh, the GTO is a dark orange. That would have been pretty. Make it glitter, like stop it. Okay, let's stop. It's just a car. And that it should be, and that it, that, okay. And that it should be dismissed that's a bad typo. Come on, really? It was solid, and he had a 350 Pontiac out of another car. Oh, yeah, just for the engine. Just for the engine. Okay. La 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 la. The legal necessity of dismissing a selective and vindictive prosecution is clear, but defendants can seldom prove that such improperly motivated prosecution has occurred because it is difficult to prove what is in the mind of prosecutors. But here, the prosecution has told us. Not only does the evidence show that Mr. Biden is the victim of a selective and vindictive prosecution, but, to use a phrase, that evidence is on steroids, bitch. The bitches, I added that. After 5 years of a thorough and what was and must continue to be a very expensive investigation, U.S. Attorney David Weiss, a holdover from the Trump administration, decided to resolve the entire investigation of Mr. Biden through a diversion agreement concerning a firearm charge and a separate plea agreement to resolve tax-related misdemeanor charges. This is the resolution Mr. Weiss suggested and wanted. His office signed the diversion agreement, which was effective upon execution by the parties, and the plea agreement, which his office argued this court should accept in open court. And this is how Mr. Weiss would have resolved this case if left to exercise his own judgment. Footnote: the extensive back and forth negotiation between the USAO and Mr. Biden's counsel regarding the prosecution's decision to resolve any and all investigations of Mr. Biden by the office is discussed in detail in the accompanying declaration of Christopher Clark, filed contemporaneously. Oh, goody. Let's see. The announcement that this case will be resolved through the diversion agreement drew sharp rebuke from former President Trump, who appointed Mr. Weiss, extremist House Republicans, and the far-right media. They made it clear that they wanted Mr. Weiss to keep this litigation alive through the presidential election, regardless of merit, and for him to bring more serious charges as a foil for the investigations and prosecutions of former President Trump. They insisted upon this even though the evidence of more serious crimes was lacking. And the only felony charge Mr. Weiss had previously filed was part of a diversion agreement for a gun charge that is widely violated, yet almost never prosecuted, and that was recently found unconstitutional by the Fifth Circuit before this case was brought. Oh, it's a real GTO. That's so cool. Because the facts in this case did not change and the law only became more difficult for such prosecutions, the public record supports no conclusion other than Mr. Weiss changed his decision because he buckled under political pressure to bring more severe charges. After this court questioned the mechanics of the plea agreement, not its substance, and asked for supplemental briefing on why the parties believed the plea agreement could work as drafted by the prosecution, Mr. Weiss chose to abandon the plea agreement rather than defend his prior work. Prosecutors told defense counsel the plea agreement they had just advocated for was withdrawn, and that they would no longer honor the diversion agreement that they had signed and executed, although they refused to say why or how they wanted to proceed instead. Ultimately, as the political pressure continued to mount, Mr. Weiss brought this indictment in violation of the diversion agreement that he had reached, and he added 2 new felony charges. The new charges do not rest upon any newly discovered evidence. The event in question happened 5 years ago in October 2018. It was investigated at that time by local law enforcement, and separately for months by Mr. Weiss's office before the resolution occurred. On December 7th, 2023, after being berated by Republican members of the House, who took the unprecedented step of calling him to testify before Congress concerning an active investigation and prosecution, Mr. Weiss buckled and upped the ante yet again by converting the 2 misdemeanor charges for failure to timely file taxes into a 9-count indictment in California based on the same evidence, which I have pulled up. Based on the same evidence he had acquired over 5 years before the June agreement had been made. Does seem kind of unfair. Nothing changed since Mr. Weiss had agreed to the appropriate resolution of the case, except the law restricting the possession of handguns became even harder to prosecute, and the pressure from his right-wing base to bring more serious charges grew louder and louder. That's great. Tom, those are really cool. This is perhaps the clearest of cases of prosecutors making prosecutorial decisions for political reasons, selectively and vindictively prosecuting Mr. Biden based on his familial and political affiliation with his father, the President of the United States. The facts of Mr. Weiss's high-profile flip-flop speak for themselves, and the fact that he traded his own judgment for the judgment of President Biden's political enemies is not lost on anyone. In fact, the same Republican House members who exerted this pressure on Mr. Weiss have claimed credit for causing Mr. Weiss's about-face. Members of Congress celebrated the end of the deal as they're doing. House Oversight and Accountability Committee Chairman James Comer declared outside the Capitol, quote, "I think that you're seeing our investigation that shined as a light on the many wrongdoings of the Biden family has picked up a lot of credibility today. Because now we see that there are a lot of crimes that this family's committed and that played out in court today." End quote. House Ways and Means Committee Jason Smith told Fox News that day, "Justice has been served," and later tweeted, "Announcement of a special counsel only happened because congressional GOP exposed the two-tier judicial system by shining light onto the investigation into Hunter Biden's penis. I mean, alleged financial crimes and the political interference that shielded him both and POTUS from scrutiny." And 4 days ago, after the special counsel decided to pile on new tax charges in California, Chairman Smith claimed credit for that too, and vowed his pressure would not end. Smith vowed, "This is far from over," and in an effort to politicize the matter further, suggested that tax charges against the president's son somehow confirms the need for Congress to move forward with an impeachment inquiry of Joe Biden. All right. Thank you. Oh, bye, Scott. See you later. Have a wonderful day at work. It's Monday, but it's almost over. And by almost, I mean a number of hours away, but that's neither here nor there. It's still almost over. I choose to believe. All right, let's traipse through this factual background. In 2018, Trump started ramping up efforts to deride his political rivals ahead of the 2020 election. Joe Biden was high on his list, and Mr. Trump began a campaign of disparagement aimed at everything and anything associated with former President Joe Biden. We need some like montages. I don't know. Maybe we don't. I don't know. Hunter Biden, Joe Biden's son, became a frequent target of Trump's attacks. Likely not coincidentally, also in 2018, federal investigators began their investigation of Mr. Biden's tax and financial affairs and his foreign business dealings. Oh, let me go back up here. Let me just, indeed, if this case is not the one to dismiss, okay. All right, so we didn't miss anything big. All right, so this is the press release. My name is Sweetheart Deal. Okay, that's fine. That's not really important. Without bothering with facts or evidence, President Trump started accusing Mr. Biden of corruption and calling on his attorney general to investigate. Discussing, there's a section, see info, blah, blah, blah. Mr. Barr declined President Trump's request that he appoint a special prosecutor, securing DOJ's position on President Trump's payback list. But he did assign U.S. Attorney David Weiss to secretly investigate Mr. Biden. This investigation, which Mr. Biden publicly announced when he learned of it on December 10th, 2020, was far-reaching and largely based on conjecture, as investigations of a single target in the independent and special counsel eras tend to be. Nevertheless, the investigation may soon outlive its second presidency. And while Mr. Trump's accusations were hollow, they set political forces in motion that DOJ was neither equipped nor motivated to resist. This is actually kind of good. Oh, thank you, Tom. I will definitely look for that. Mr. Biden's gun purchase and DOJ's initial charging decision. The same year President Trump started spinning his yarn, Mr. Biden bought a small firearm that he owned for a mere 11 days, never loaded and never fired. The gun was discarded and then discovered and investigated by local police, who decided no charges were warranted. Federal law enforcement was aware of the gun purchase and Mr. Biden's past drug use, which had been widely reported. Well, that's not really, okay. Although there is a criminal offense for possession of a firearm by a user of a controlled substance, DOJ almost never brings charges under that statute absent some aggravating factor, such as the use of a firearm in a violent crime, none of which are present here. In fact, the year before, the Attorney General Jeff Sessions, you remember Jeff Sessions? You remember? You remember him. Yeah, you do. Had specifically directed DOJ to reserve the statute for prosecuting criminals responsible for significant violent crime, to conserve limited department resources. Mr. Biden has no history of violence and has never posed a risk to public safety. Indeed, the New York Times reported that Mr. Weiss told an associate that he preferred not to bring any charges, even misdemeanors, against Mr. Biden because the average American would not be prosecuted for similar offenses. That's a quote from the New York Times. Thus, consistent with its practices and directives and the way it treats everyone else, DOJ exercises prosecutorial discretion and declined to pursue gun charges, mounting political pressure and the DOJ's second charging decision. Having determined that chun charges, having determined that gun charges were not warranted, DOJ continued to, quote, investigate Mr. Biden while weathering increasing political pressure by President Trump and other prominent Republicans eager to find something they could use against Mr. Biden's father, even though there is no evidence that Mr. Biden's father had engaged in any wrongdoing with his son. But DOJ's investigation was not producing evidence of corruption. So Mr. Trump and his supporters resorted to Mr. Biden's personal history as both a means of demeaning the Bidens and leveraging DOJ. President Trump, for example, whose campaign started selling, quote, "Where's Hunter?" t-shirts, referencing his baseless accusations in 2019 that Mr. Biden should be charged with a litany of corruption offenses. And President Trump used Mr. Biden's struggle with addiction to attack President Biden in a presidential debate in 2020. Representative Matt Gaetz, Mr. Foreheads, argued on live television that Mr. Biden's history with drugs must mean he was corruptly appointed to his position on the board of Burisma, I'm going to say. Let's see. Inside the account is most likely true. I think we read that. Okay. The Ukrainian, he was appointed to the board of the Ukrainian company Burisma Holdings. After President Biden assumed office, Senators Chuck Grassley and Ron Johnson publicly announced that they sent letters to the Secret Service, the FBI, and the ATF, demanding all records related to the firearm purchase by Mr. Biden and accusing the investigative agencies of political favoritism. And in 2022, Fox News aired a leaked private voicemail, allegedly from President Biden to Mr. Biden, expressing the president's love and support for his son, which the network claimed reflected Mr. Biden's drug use at the time he purchased the firearm, a direct challenge to DOJ's refusal to charge Mr. Biden under Section 922. The Republican opponents of the Biden administration were quick to jump on. Setting a new low for the standards of decency in Congress, Marjorie Taylor Three Toes used an official oversight committee proceeding to gratuitously display blown-up sexually explicit and lewd photos, albeit unlawfully obtained. That's important. Of Mr. Biden, under a guise that fooled no one, that her actions had something to do with, quote, legislating. Suffice it to say, these opponents of President Biden are not bashful about exploiting Mr. Biden and his personal life to advance political agendas, even though many of these critics have objected that criticism of President Trump's children should be off limits. DOJ has been in an uncomfortable position ever since President Trump first bullied the agency into opening an investigation. Regrettably, the DOJ finally buckled under the political pressure and rather than disclosing the investigation based on the lack of aggravating factors, contacted Mr. Biden's counsel on May 15, 2023 to propose a non-prosecution agreement for the gun charges and then later to further require a guilty plea by Mr. Biden to two misdemeanor tax charges that IRS agents cobbled together in its own self-defense against compounding political aggression even though the agency had already exercised its prosecutorial discretion and determined that these charges should not be brought. Oh, sorry, I struggled with that. Oh, the IRS whistleblowers. They're whistleblowers. You know how to whistle, Steve. You just put your lips together and blow. Sorry, my voice is crappy. That wasn't very sexy. Okay. DOJ was once again satisfied with its determination that prosecution was unnecessary and even sent Mr. Biden's counsel a framework for the resolution, a DPA, used in another recent case involving Aegis Electronic Group, where DOJ also agreed to defer charges. But politics again intervened when the IRS agents actually investigating Mr. Biden, Gary Shapley, and Joseph Ziegler, championed by House Republicans, went public, including making numerous media appearances with claims that the DOJ and Biden administration were interfering with the investigation of Mr. Biden's taxes. Let's see this. Traditionally, it has been viewed as unseemly, and appropriately so, to target children of the president or other public officials with negative publicity that members of the general public would not receive. Presidents have opened family members up to political attacks by putting them in political position, as President Kennedy did with his brother and President Trump did with his daughter and son-in-law. Nevertheless, many Republicans objected to the scrutiny given to President Trump's daughter, Ivanka Trump, as an unfair personal attack on the child of a president. And yet, she's such a see you next Tuesday. How can we stop? A few weeks later, Republicans in the House Ways and Means Committee voted to release hundreds of pages of confidential grand jury material and taxpayer information in violation of numerous federal laws, and in so doing, dumped into the public IRS's investigative files of Mr. Biden for all to read. This unprecedented disclosure of case materials for an active investigation, followed by the purported whistleblowers, in quotation marks, public media campaign, prompted further congressional investigation, and Mr. Weiss seemingly decided an agreement deferring the tax charges was no longer politically palatable. Despite having already decided the tax charges should be deferred, Mr. Weiss reneged on the deal and demanded Mr. Biden plead guilty to 2 misdemeanor tax charges as part of the agreement to defer the gun charges. As the New York Times explained, Weiss was willing to conclude the investigation without even as much as a plea deal before the IRS agents accused the Justice Department of interfering. Let's see what this says. The same Republicans who applaud the acts of the IRS agents as purported whistleblowers who unlawfully publicly disclosed Mr. Biden's confidential tax information have hypocritically attacked the Biden administration for not insisting on more severe punishment of an IRS agent who unlawfully leaked Mr. Trump's confidential tax information. Thorpe. So there you go. Then, just 4 days ago, responding to the continued roars from his political party, Mr. Weiss filed 9 counts, felonies and misdemeanors, against Mr. Biden in Los Angeles, based on the same. I wonder if I can attend that court case. Do you guys think I'll be able to attend that court case? I think it's time to look into that. Although maybe this will go away, which would be great. Separate, right. Oh, okay. A separate diversion agreement for the firearms charges subject to a 24-month probationary period. Yet, after prosecutors sent the plea agreement and diversion agreement to the court on June 8th and filed a letter describing the deal's structure on the docket in Delaware on June 20th, 2023, the political backlash was forceful and immediate. As discussed in depth below, even before the court raised questions about the mechanics of the agreement on July 26, politicians and Mr. Trump were denouncing it as a sweetheart deal, a slap on the wrist, and a traffic ticket, accusing DOJ of favoritism and misconduct, and using the excuse to interfere with and further co-opt its investigation. You have to call them? Call who? Now I forget. I forget what we were talking about. So dumb. Okay. Critics of the deal did not stop at condemnation. They immediately deployed their social and political influence to poison the deal and bring DOJ to heel. Leaders of the House Judiciary, Oversight and Accountability, and Ways and Means Committees opened a joint investigation into the case and DOJ's plea negotiations. On June 23rd, Ways and Means Committee Republicans voted to publicly release closed door testimony from the two IRS, quote, whistleblowers who, in the words of Chairman Smith, describe how the Biden Justice Department intervened and overstepped in a campaign to protect the son of Joe Biden by delaying, divulging, and denying an ongoing investigation into Hunter Biden's alleged tax crimes. Separately, about attending. Oh, yeah, I'll have to call him. Now I get it. I'm so fucking. Woo, okay. Yeah. Is it any wonder you have 8 people watching? Would I hope it's good background. Let's see. Separately, Congress kept up the ad hominem attacks. It was at the hearing of the House Oversight and Accountability Committee in July 2023, for example, that Marjorie Taylor Three Toes made her display of what is colloquially called revenge porn for no other reason than to denigrate Mr. Biden and his family. Then, on July 25th, just one day before Mr. Biden's scheduled plea hearing, Chairman Smith actually tried to intervene in this case to file an amicus curiae brief in aid of plea hearing, United States v. Biden, in which, with no shame about doing real political interference while complaining about non-existent involvement by others, he encouraged the court to consider the unfounded allegations by the IRS agent whistleblowers that the probe into Mr. Biden was tainted by political interference and attaching transcripts of their testimony, which contained confidential taxpayer and grand jury information on the public docket. Smith memo. The defendant appears to have benefited from political interference, which calls into question the propriety of the investigation of the U.S. Attorney's Office. It is critical that the court consider the whistleblower materials before determining whether to accept the plea agreement, close quote. The two, quote, whistleblowers who were the case agents on the investigation that was being pursued then publicly testified before Congress about their work on the investigation as agents, disclosing further confidential grand jury testimony and taxpayer information about Mr. Biden in the process. It is not unusual that agents may disagree with the charging decisions ultimately made by prosecutors, but that does not give those agents a right to disclose confidential tax information publicly and to become part of a right-wing effort to turn this prosecution into a political game. Instead, it is clear that these agents had a political axe to grind with Mr. Weiss and his team and were prepared to weaponize their power no matter the cost to Mr. Biden and his right to a fair process. As noted above, non-prosecution was consistent with DOJ policy, and even prosecutors under President Trump's own Attorney General Barr had declined to indict Mr. Biden. The whistleblower accounts that contradicted testimony to Congress by Attorney General Merrick Garland that Mr. Weiss had complete authority to make all charging decisions related to the investigation. Their testimony was in turn contradicted by 10 officials from DOJ, FBI, and IRS who were in meetings and conversations in which Mr. Weiss's authority was confirmed. No one corroborated the IRS agent's claims. Mr. Weiss tried to do damage control, writing to House Judiciary Chairman Jim Jordan on June 7th, 2023, that he had, quote, ultimate authority over this matter, including responsibility for deciding where, when, and whether to file charges. But after the court raised questions about the plea agreement on July 26, Mr. Weiss, feeling the weight of the Republican criticism, jumped at the chance to escape the deal he had struck and that had subjected him to public condemnation. The court, while raising questions concerning some of the procedures in the agreement for alleging breach, never stated or insinuated that the deal would be unfair without more serious charges being levied against Mr. Biden. Republican members of Congress were quick to take credit for sabotaging Mr. Weiss's proposed plea agreement, celebrating the end of the deal as they're doing. Okay, so I think this is a repeat A repeat. And now these same Republicans are praising the new tax charges that were just piled on in California years after the DOJ had the relevant facts and after they agreed to resolve them with a plea to a misdemeanor defense, while simultaneously criticizing them as an effort to protect Mr. Biden and demanding even more charges. What does this say? I don't know what that is. Oh, that's probably from the judge. In other words, these officials have accused DOJ of trying to protect Mr. Biden by resisting calls to investigate him based on baseless accusations in the first place. 2, criticize DOJ for declining to charge him with a crime for which no similarly situated person would be charged. 3, claim credit for Mr. Weiss caving to their pressure and forcing Mr. Biden to enter a plea agreement he should never have had to consider. 4, claiming credit for Mr. Weiss subsequently yielding to their pressure and scrapping that plea deal. 5, boasting the appointment of a special counsel, which those officials had demanded for years was their doing. And 6, declaring that they were the cause for Mr. Weiss bringing misdemeanor and felony tax charges DOJ had not believed were warranted until they intervened. This ludicrous and shameless behavior would be comical if it were not so deeply unfair to Mr. Biden, embarrassing to the country, and offensive to the concept of justice. It is overwhelmingly clear that nothing the Justice Department could charge Mr. Biden with, no matter how unjustified, would satisfy these officials, which is no surprise given that their real objective is to attack the president and the Democratic Party before an election. So there. Let's see. As if the over-the-top and excessive natures of these charges was not apparent from the face of the document, and in light of the 2 misdemeanors previously agreed to, on an appearance CNN that evening, former Attorney General Eric Holder even stated that both Republican and Democratic former U.S. attorneys who he has spoken to indicated that based on the facts, quote, this was not a case we would have brought. Mr. Holder went on to say that he believes Mr. Biden is, quote, being treated perhaps a little differently because of who he is. There's a political component to this case. I think that there is certainly political pressure that exists in this case that you would not have see with regard to other matters. Thank you, Eric Holder. Okay. In sum, politicians and public officials at war with their political rivals are flouting separation of powers to intentionally interfere with the executive branch's handling of this case, and the casualties are Mr. Biden's constitutional rights, any objective appearance of fairness, and public confidence in the justice system. DOJ is responsible for preventing this, but the agency was bullied into investigating Mr. Biden in the first place, and now everything the agency does or does not do earns it condemnation and reprisal. 2 typos. As bad as this already is, it will only get worse. Former President Trump, for example, has vowed, if elected, to, quote, appoint a real special prosecutor to go after the Biden crime family, defund DOJ until the department comes to its senses, and revive an executive order that allows him to fire executive branch employees without cause. Indeed, in response to direct questioning on live television about whether he would abuse the powers of the presidency to get even with his political rivals, the most he was willing to offer that was to only act as a dictator on, quote, day 1 of his presidency, although history does not show that dictators peacefully give up that power once assumed. And there is no doubt that his hit list includes Mr. Biden and Mr. Weiss, if Mr. Weiss fails to aggressively prosecute Mr. Biden. In his own motion to dismiss for discriminatory prosecution, Mr. Trump insists he's only being prosecuted because he targeted Mr. Biden in the first place. This no doubt exerts considerable pressure on Mr. Weiss to curry favor and avoid the wrath of a potential future president by complying with his demands. What does this say? See Kristen Holm. Trump's radical second-term agenda would wield executive power in unprecedented ways. No duh. That's even Mr. Trump cannot fail to see the hypocrisy in championing the constitutional principle that no one should be subject to a selective or vindictive prosecution. Okay. Congress is way ahead of him. Chairman Jordan, Chairman Comer, and Chairman Smith, Manny, Mo, and Jack, as I like to call them, have made it their personal and political missions. The pep boys, if you will, of breaking the engines. political missions to come up with, or, if necessary, manufacture evidence that Mr. Biden committed a crime. And they are using the power of 3 congressional committees to discipline Mr. Weiss for not punishing Mr. Biden more severely. They even pressured Mr. Weiss and 2 other U.S. attorneys to provide testimony regarding the decision not to bring charges, a nearly unprecedented abuse of power and intrusion on a pending investigation by the Department of Justice. And now, those same congressmen are trying to force Assistant U.S. Attorney Leslie Wolf, who negotiated the diversion agreement and plea agreement, to provide further testimony about the investigation. Notably, capitulating to this pressure is contrary to longstanding and sensible DOJ policy against congressional interference. And speaking of which, DOJ has a long history of condemning this interference by Congress. In a November 30, 1982 letter to Rep. John Conyers, for example, Attorney General William French Smith, with the knowledge and concurrence of President Reagan, expressed the longstanding position of the executive branch that DOJ generally, quote, declines to provide committees of Congress with access to or copies of law enforcement files except in the most extraordinary circumstances, close quote. The letter quotes Attorney General Robert Jackson, stating that all investigative reports are confidential documents of the executive department and, quote, disclosure of the reports could not do otherwise than seriously prejudice law enforcement, close quote. Let's see what this big old thing here. While threatening DOJ, okay. There have been only a few occasions involving high-level public officials, where the supervisor of an investigation appeared before a congressional committee while the investigation was pending. One instance was the investigation prompted by the Watergate break-in and cover-up implicating the President of the United States, and the other was under the Independent Counsel statute and the proceedings of Cabinet Officer Michael Espy. On Watergate, only after the criminal events in question had already been exposed to the public and there was minimal risk of additional pre-trial publicity and prejudice did the special prosecutors testify. Likewise, the independent counsel's testimony in 1997 about Mr. Espy's alleged wrongdoing came only after the government's successful prosecution of Espy's chief of staff, Ronald Blackley, on 3 federal counts. Here, Mr. Biden is a private citizen, and Mr. Weiss testified only a few weeks after Mr. Biden was charged in Delaware. I think he's doing a pretty good job of arguing this. It's also quoting former Attorney General Thomas Copper. I don't know how to say that. The executive cannot effectively investigate if Congress is, in a sense, a partner in the investigation. Yeah. If a congressional committee is fully apprised of details of an investigation as the investigation proceeds, there's a substantial danger that congressional pressure will influence the course of the investigation, close quote. Noting the, quote, well-founded fears that the perception of the integrity, impartiality, and fairness of the law enforcement process as a whole will be damaged if sensitive materials are distributed beyond those persons necessarily involved in the investigation and prosecution process. And they've already proven, this is a Lolo footnote, they've already proven that they can't fucking handle private information. They don't care. It all goes out. If someone on the left did that, I mean, people would freak out. Freak out. Like freak, say chic. Right? All right. I think I need a little power situation here. Hold on. There's a whole lot of money. Oh, man. Is this not a cord? Dagnabbit. Oh, hold on. I've got to get a little power thing for the. Oh, wait. Nope. I got a little. All right. I'm going to. Okay. Hold on. I just need to. I need to just. I'll be right back. Crap. Wow. Hold on. I'm going to be right back. You get a little music. BRB. Oh, sorry about that. Okay. Hold on, hold on. Okay. Let me turn this music off. Thank you. Oh, my tummy's growling. I'm hungry. I might have to eat soon. Okay. Let's see. Where are we? Do. Please like, share. Please like, share. Thank you. And I'm not on Twitter, so I need your help. I might have to come back and close out my Twitter existence, but I don't have any. I don't have any reach other than Twitter. So I need fuck Twitter. I fucking hate it. Okay, here we go. Let's see. What do we do? The letter quotes Attorney General Robert Jackson, stating that, quote, all investigative reports are confidential documents of the executive department. Oh, that's actually, we already read all that. Let's see. Noting the well-founded fears that the perception of the integrity, impartiality, and fairness of the law enforcement process as a whole will be damaged if sensitive materials are distributed beyond those persons necessarily involved in the investigation and prosecution process. Investigative reports might be the grossest kind of injustice to individuals as they include leads and suspicions, and sometimes even the statements of malicious or misinformed people. And even though later and more complete reports exonerate the individuals, we know that a correction never catches up with an accusation. Good point. As Deputy Assistant Attorney General Robert Shanks explained in 1984, pretrial publicity originating in Congress can be attributed to the government as a whole and can require postponement or other modification of the prosecution on due process grounds. The discretion of prosecutive officials to conduct their investigations and trials in the manner they deem to be the most efficient and constructive can be infringed by precipitous disclosures which prompt a court to impose remedial procedural obligations upon the government. The Department of Justice also has an obligation to ensure that the fairness of decision-making with respect to its prosecutorial function is not compromised by excessive congressional pressures, and that the due process rights of those under investigation are not violated. Just as an agency's ability to fulfill its statutory obligation may be impermissibly strained by pressure from the legislative branch during the administrative decision-making process, excessive interference with the exercise of prosecutorial discretion can substantially prejudice the rights of persons under investigation. Persons who ultimately are not prosecuted may be subjected to prejudicial publicity without being given an opportunity to cleanse themselves of the stain of unfounded allegations. Moreover, the injection of impermissible factors in the decision whether to initiate prosecution offends not only the rights of the accused, but also the professional obligation of government attorneys to the integrity of the judicial process and ultimately the obligation of the executive faithfully to execute the laws. Hi, Paulina. It's so good to see you. Happy Monday. I miss your morning tweets that are like very centering. So know that you're missed. I might come back just for those. Okay, let's see what we got here. So this is from 1984. Let's see. Attorney General John Ashcroft. Oh, we can't stand him. I elaborated on this policy and the reasons behind it in 2012. The need for confidentiality is particularly compelling in regard to the highly sensitive prosecutorial decision of whether to bring criminal charges. The department's attorneys are asked to render unbiased professional advice about the merits of potential criminal cases. The formal mechanism by which this process occurs is the preparation of prosecution and declination memoranda. In short, these documents review the strength of the evidence, substantive legal issues, policy considerations, and overall likelihood of success if the case were to proceed. If these deliberative documents are subject to congressional scrutiny, we will face the grave danger that prosecutors will be chilled from providing the candid and independent analysis essential to the sound exercise of prosecutorial discretion and to the fairness and integrity of federal law enforcement. Just as troubling, the prospect of congressional review might force prosecutors to err on the side of investigation or prosecution simply to avoid public second-guessing. This would undermine public and judicial confidence in our law enforcement processes. Well, who knew he would Even a broken clock is right twice a day. We have significant concerns about oversight requests for prosecution and declination memoranda. The nexus between such inquiries and the purpose of oversight is questionable, and this kind of demand threatens to politicize the criminal justice process. Legislative branch pressure on prosecutorial decision making is inconsistent with the separation of powers and thereby threatens individual liberty. Congress cannot justify a demand for decision-making document based on its disagreement with a prosecutorial decision. In any event, even if the committee has a legitimate oversight interest in these documents, its oversight needs cannot outweigh the executive branch's interest in the confidentiality of prosecutorial decision-making and our concerns about congressional influence on such decision-making in individual cases. Then there's a quote from Elena Kagan's Presidential Administration Harvard Law Review, where she writes, in 2001, resolution of prosecutorial questions usually is conceived as lying at the heart of the executive power vested in the president. But it is in this area, because so focused on particular individuals and firms, that the crassest forms of politics, involving at the extreme personal favors and vendettas, pose the greatest danger of displacing professionalism and thereby undermining confidence in legal decision-making. Well, that's pretty fancy. Similarly, former Attorney General Benjamin Civiletti warned that it could be impossible for an accused to persuade DOJ not to indict. To be heard by the prosecutor, if she has to shout over loud protestations by members of Congress by urging indictment of this very individual, or that members of Congress are standing ready to chastise the prosecutor if no indictment is brought. Sentenced to 4 years for fraud. What's Nicola? What is that? I'm not familiar with that case. Let's see. To imagine such a scenario is to understand why congressional involvement is so prosecutorial decisions can be perilous to civil liberty. The Attorney General cannot effectively and fairly enforce the laws when career prosecutors are receiving pressure from Congress. Electric semi-trucks. Oh. Wow. Oopsie. I'll have to look up on that. Heritage. Oh, that is precisely the situation. Failure to adhere to these policies is a recent trend. And this is not the first time it has happened in response to pressure from Mr. Trump. Deputy Attorney General Rod Rosenstein failed to follow these policies with respect to the investigation of Russian interference with the 2016 presidential election, which I think we're going to come back to, by the way. I think that's all about to be opened back up. Oh, well, strap in, kids. Drawing criticism from DOJ and Congress alike. As former Deputy Assistant Attorney General Harry Littman, now a professor of constitutional law at the University of California at San Diego, explained, Deputy Attorney General Rod Rosenstein has capitulated to political pressure from the president and his allies in Congress. He has yielded to demands from the most rabid opponents of Special Counsel Robert Mueller's probe in a way that harms the long-term interests of the Justice Department. He was right. And likely does little to protect the probe or Rosenstein's own job. Rosenstein's own job. While requests from Congress are always subject to some ad hoc back and forth, it is about as hard and fast a rule as there is that the Justice Department will not hand over documents relating to a still active investigation. And for good reason. It could compromise the investigation, unfairly expose uncharged individuals, and provide a roadmap for defendants to sculpt their stories. It is precisely that the practice is inflexible and long established that provides department officials the wherewithal to resist the often urgent saber-rattling calls from the Hill to provide documents in pending investigations. Former Senator Carl Levine, Democrat from Michigan, agreed. Only the executive branch has the constitutional authority to prosecute. Congress can, when it comes across what it thinks is criminal activity, refer a matter to the Justice Department for possible prosecution. This is the mistake I think Mueller made. He didn't refer it, and that was bad. He should have. But its role and authority stops there. Should it seek to try and influence the discretionary authority of the executive branch in a prosecutorial matter, the third branch of government, the judiciary, could throw out the prosecution based on political influence. But Congress has always avoided seeking documents from ongoing criminal investigations. That was my experience, and that's the way it should be. That is a bright red line that should not be crossed. There is no doubt there is no doubt that the DOJ is in an unenviable political position with respect to this case. But as DOJ itself has long believed, Mr. Biden's rights come first, and efforts by members of Congress and the former president to interfere have tainted this prosecution beyond purification. As a result, there is no constitutional option but to dismiss. Legal standards. Okay, well, these might not be quite as interesting. For almost 100 years, with an evil eye and an unequal hand, so as practically to make unjust and illegal discrimination between persons in similar circumstances. Oh, that was only 1983. I was acting like that was like super. Well, maybe. Oh, it was 1886. Okay, I gave it the proper, Thus, although prosecutorial discretion is broad, it is not unfettered. In particular, the decision to prosecute may not be deliberately based upon an unjustifiable standard such as race, religion, or other arbitrary classification. Oh, 1985. God damn it. Indeed, nothing can corrode respect for rule of law more than the knowledge that the government looks beyond the law itself to arbitrary considerations. Selective prosecution then can become a weapon used to discipline political foes. That's right. I said it. The government cannot base its decision to prosecute on a defendant's political beliefs. Criminal prosecution should not, of course, be initiated because the defendant belongs to a particular political party. Relatedly, when the prosecution ups the ante by bringing more severe charges in response to animus, the prosecution is vindictive. That's right. 1996 Mansour, look it up. Importantly, while many selective prosecution cases involve an unjustifiable standard such as race, religion, or other arbitrary classification, including the exercise of protected statutory and constitutional rights, improper or vindictive purpose exists whenever a charging decision is made for reasons other than legitimate prosecutorial considerations. In other words, prosecutors may target conduct, not individuals. Dismissing a vindictive prosecution based on a government's institutional stake in discouraging third-party conduct and avoiding contempt for federal law enforcement. Let me see what this footnote says. Biden has already sought discovery from DOJ and information from third parties with knowledge of former President Trump's influence, and DOJ has not responded to the request and filed an opposition for this information to be disclosed. Interesting. Okay, let's see. This is vindictive prosecution. In a vindictive prosecution. Prosecution is abound some valid ground. Mere random selection would suffice, since the government is not obligated to prosecute all offenders, but no effort was made to justify these prosecutions as a result of random selection, and Steele's evidence was inconsistent with such a theory. Interesting. Prosecutors may not bring charges to target specific persons. Yeah. Let's see. When prosecutors bring charges for an improper purpose, one that targets an individual for who he is rather than his allegedly criminal conduct, they violate a defendant's due process and equal protection rights. Where's my weed? Speaking of equal protection, where's my weed? Trying to warm it up. Hold on. I'm warming it up. Okay. Oops. Oh, cool. Okay. Oh, you actually need to be plugged in. But your sister doesn't. Okay. Sorry. Okay, let me take a little sip of coffee. Oh my God, that's so good. Okay. Woo! They violated defendants' due process and equal protection rights. It does not matter whether the improper purpose belongs to the prosecution or a third party with influence, as any external interference in the independent judgment of prosecutors is problematic. Quoted Mansour, where outside party in some way prevails upon the prosecutor in making a decision to seek an indictment, the ill will, whoever its bearer, may be imputed to federal prosecutors. That's Adams, baby. Oh, wait, no, that's not. That's Mansour. La 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 la. Evidence. Okay, so this is from 1989. Evidence that a party had instigated and pushed the prosecution justified discovery into whether party was able to prevail upon the Department of Justice to institute a prosecution that otherwise would not have been undertaken. Yeah, it does seem like this is an important point. It seems like it would be important for Hunter's team to have access to the information. That seems important. Otherwise, how do you really know how to craft a defense? I mean, not that I know I'm not making this very. I'm not that. Yeah. Charges must be dismissed. Preservation. Okay. Executive selectively prosecute someone based on impermissible considerations. The equal protection. So the argument, the case exists because Mr. Biden is politically affiliated with his father, the sitting president, and a candidate for re-election at a time when a historically divided nation prepares for a contentious presidential election. From its inception, the investigation of Mr. Biden has been polluted with politics. President Trump, without any evidence, started accusing Mr. Biden of corruption in 2018, claims that featured prominently in his presidential campaign. Discovery is a fundamental pre-courtroom stage of litigation. Discovery, yes, right? I wonder why they've refused. Where a defendant has not cared. Oh, wait. Wait, where was I? Since then, the investigation has been a hot button topic for Republicans who have made it a centerpiece of their campaign to discredit the Biden administration and challenge President Biden's reelection campaign. When a defendant has not carried his burden, but has demonstrated, quote, a colorable claim, discovery in an evidentiary hearing should be permitted. So that's just that pushing for that. Okay. Indeed, now it has even become the basis for an expected vote on impeachment in the next few days, which they did. As a holdover from the Trump administration, Mr. Weiss faces political pressure from his own party to pursue Mr. Biden more aggressively. I just want the maggots who are listening, just swap out the name Biden for Trump and then tell me what you think. That's what I want. That's your mental exercise for the moment, because I know you're watching. I know Ron Volts is fucking watching because he's a member. There's others. Chill Pill, I think, is a member. Like, there's all these like accidental members who are chuds. Sorry, not sorry. So learn something, please. While you hate me, learn something. Let's see. This case was the inevitable result of the devolution into crass politics. Under mounting pressure, yet unable to find evidence of Biden family wrongdoing, DOJ has reached for an unconstitutional statute that its official enforcement policy expressly reserves for cases impacting public safety, and charged Mr. Biden with a crime based on facts DOJ has known and chose not to act upon for years. DOJ then leveraged Mr. Biden into a plea deal he should never have had to consider, hoping to shoot for some middle ground between Democrats poised to condemn this vindictive prosecution and Republicans eager to decry favoritism, ironically by treating Mr. Biden as it would anybody else. When that backfired, DOJ found itself facing down a Republican congressional inquiry into its charging decisions and plea negotiations, so the agency abandoned the deal, forcing Mr. Biden to defend himself against felony charges DOJ was happy to defer when it believed that was the most politically advantageous strategy. This record should raise more than judicial misgivings. Politicians are not just wooing and wheedling, but openly interfering with this case, poisoning the potential jury pool, and shaking public confidence in the judicial system. And Republican House members are boasting about their success in torpedoing the deal struck by Mr. Weiss. To be clear, no new facts had emerged after the prosecution proposed the plea agreement after 5 years of a thorough investigation, and the prosecution's choice to abandon the plea agreement framework and insist on charging multiple felonies despite the executed diversion agreement that confers immunity. Let's see. In fact, one of the primary congressmen pressuring the DOJ and U.S. attorney in this case, Oversight Chairman Jimmy Comer, is actually using his attacks as a fundraising vehicle for his campaign. Jimmy Comer, what are you doing? You're naughty. The only thing that changed, other than that the law underlying the gun charge was successfully challenged in several federal courts, including the Fifth Circuit, is that the prosecution's Republican benefactors turned on them and exerted pressure on them to take a more aggressive line against Mr. Biden in time for the election. Just as the numerous statements from former attorneys general, Republican and Democrat appointees attested, it is no secret that excessive interference with the exercise of prosecutorial discretion can substantially prejudice the rights of persons under investigation. Wait. Bosher v. Sinar, finding congressional interference with the executive function unconstitutional because, quote, the Constitution does not contemplate an active role for Congress in the supervision of officers charged with the execution of law it enacts. Oh my God, I'm sorry. Due process violated where officials acted based on fear of negative public reaction and legislative reprisals. So there's a bunch of quotes of how, okay. Excuse me. Martis. Quote, in some circumstances, pressure from congressmen and senators violates the due process rights of the parties involved, you think? That is why the Department of Justice has an obligation to ensure that the fairness of the decision-making with respect to its prosecutorial function is not compromised by excessive congressional pressures, and that the due process rights of those under investigation are not violated. The judiciary has always borne the basic responsibility for protecting individuals against the unconstitutional invasions of their rights by all branches of government. Mr. Biden is a victim of selective prosecution. Okay, sensitive inquiry. To prove selective prosecution, Mr. Biden must show the prosecution exercises discretion with, quote, discriminatory purpose and discriminatory effect. When a defendant has alleged a prima facie case of selective prosecution, the burden shifts to the prosecution to, quote, show the selection process actually rested upon some valid ground in Steele. The court's supervisory powers provide an alternate basis to dismiss the indictment. Dixon v. D.C., I conclude that in this case, our supervisory power must be used to protect the purity of the government and its processes. Accordingly, I would vacate both judgments below and remand to the trial court with instructions to dismiss the information. United States v. Banks, quote, although it hurts me deeply, I'm forced to the conclusion that the prosecution in this trial had something other than attaining justice foremost in its mind. The waters of justice have been polluted, and dismissal, I believe, is the appropriate cure for the pollution in this case. Importantly, the prosecution's conduct need not be so unfair or imprudent as to offend due process before exercise of the supervisory power is appropriate. Instead, the supervisory power can be utilized whenever the administration of justice is tainted. There's a lot of quotations. We conclude and hold that the manner in which the prosecution obtained the indictment represented a serious threat to the integrity of the judicial process. The district's court dismissal, therefore, was a proper exercise of its supervisory power. GOJ prosecution of Biden is motivated by improper purpose. Proving discriminatory. Let me just take a drink of coffee. What's everyone doing today? My God, there's not many people here, which, I mean, I know why, but I'm just saying, are we missing anything? It's exceedingly difficult and dooms most claims, but the fingerprints of discriminatory intent are all over this case, complete with boasting my Republican House members claiming credit for coercing Mr. Weiss into changing his charging decision. So we won't read through all of this because it basically goes through the same stuff we read. The original investigation and prosecution team that negotiated the June-July non-prosecution and misdemeanor resolution of this case has been silenced and sidelined. A new team chosen to replace them with an agenda of reaching a different charging decision than the first team is now in charge. That the very prosecutors who investigated and negotiated the resolution of this case said nothing at the July 26, 2023 is both very odd and suspicious, even at the time. The fact that the DOJ has flip-flopped and brought on a new team to give a different... oh, you got all your stuff? Oh, cool. The fact that the DOJ has flip-flopped and brought on a new team to give a different answer undermine the legitimacy of the prosecution. C. Adams. Finding criticism of a charging decision by prosecution team members relevant to a determination of bad faith. As noted, selective prosecutions. Did I read this? Oh, no. As noted, selective prosecution claims include any cases where prosecutors bring charges to target an individual for reasons unrelated to legitimate prosecutorial concerns, which is clearly the case here. But even if such claims were limited to cases where prosecutors bring charges based on membership in a constitutionally protected class or in retaliation for exercise of legal rights, this case would qualify. Mr. Biden is being targeted based on his political affiliations and as a proxy for the political affiliations of his father, constitutionally protected activity. Mr. Trump is ground zero for improper motive. During his term in office, President Trump incessantly called in demagogue-like fashion on the DOJ, the media, the public, and even foreign governments to target and investigate Mr. Biden. At 2020 election rallies, for example, President Trump encouraged his audience to chant, "Lock him up," in reference to Mr. Biden. After he lost the 2020 election, Mr. Trump tweeted that, quote, 10% of voters would have changed their vote if they knew about Hunter Biden. And in his speech inciting the same crowd that went on to break into the Capitol on January 6, 2021, President Trump egged them on with the refrain, "Where's Hunter?" Other tweets during his time as president include tweets of October 6, 2019, quote, "The Biden family was paid off, pure and simple. The fake news must stop making excuses for something that is totally inexcusable. Sleepy Joe said he never spoke to the Ukrainian company, and then the picture came out where he was playing golf with the company boss and Hunter." Tweets of October 10th, 2019, quote, "Where is Hunter Biden? He has disappeared while the fake news protects his crooked daddy." Tweets of October 12th, 2019, "Where's Hunter?" All caps. Yeah, he's a jerk. Oh my God, there's more. October 13th, 2019, "Where's Hunter? He has totally disappeared. Now looks like he has raided and scammed even more countries. Media is AWOL." November 15th, 2019, quote, "Democrats must apologize to USA. Ukrainian Foreign Minister Vadim Prystaiko said that United States Ambassador Gordon Sondland did not link financial military assistance to a request for Ukraine to open up an investigation into former VP Joe Biden and his son Hunter." Tweets of September 24th, 2020, quote, "Russian billionaire wired Hunter Biden $3.5 million. This on top of all the other money he received while Joe was VP. Crooked as can be, but fake mainstream media wants it to just go away." Tweets of December 12th, 2020, quote, "Why didn't Bill Barr reveal the truth to the public before election about Hunter Biden?" And, quote, "If Biden gets in, nothing will happen to Hunter or Joe. Barr will do nothing, and the new group of partisan killers will come in and quickly kill it all. Same thing with Durham. We caught them cold, spying and treason and more, the hard part. But justice took too long. We'll be dead on arrival." And finally, December 17th, 2020, the day before the infamous West Wing meeting or residence meeting. I have nothing to do with the potential prosecution of Hunter Biden or the Biden family. It's just more fake news. Actually, I find it very sad to watch. Out of public view, Mr. Trump also improperly pressured DOJ to target and investigate Mr. Biden based on his false and baseless accusations. Examples include, on December 20th, you're so welcome, MJ. On December 27th, 2020, then acting Deputy Attorney General Richard Donahue took handwritten notes of a call with President Trump and then acting Attorney General Jeffrey Rosen, showing that Mr. Trump had instructed Mr. Rosen and Mr. Donahue to, quote, "figure out what to do with Hunter Biden," and indicating that Mr. Trump insisted, quote, "people will criticize the DOJ if he's not investigated for real." Former Attorney General William Barr's book recalled an earlier vignette in mid-October 2020 in which President Trump called Mr. Barr and inquired about the investigation of Mr. Biden, which Mr. Barr says ended with Mr. Barr yelling at Mr. Trump, quote, "Damn it, Mr. President, I am not going to talk to you about Hunter Biden, period." Case files provided by and testimony from IRS whistleblower, in quotes, Mr. Shapley, revealed that around the 2020 election, all aspects of the investigation into Mr. Biden, quote, needed to be vetted with USA Weiss and DAG Donahue, and that no proactive interviews have occurred as a result of guidance provided to the investigative team by the Deputy Attorney General's office, among others. IRS whistleblower Mr. Ziegler testified that then Attorney General Barr ultimately made the decision to put Delaware in charge of the investigation and, quote, to join two investigations together in 2019 at a time when President Trump's personal attorney, Rudy Giuliani, was already seeking dirt on Hunter Biden in Ukraine. Assistant U.S. Attorney Wolf told the investigative team in or around September 3rd, 2020 that, quote, United States Attorney Weiss talked to Deputy Attorney General Donahue and the DAG's office under President Trump, not President Biden, quote, is the one who made the decision not to take further overt investigative steps around the 2020 election. Separately, also in an unprecedented interference in a criminal prosecution, which as a former U.S. attorney he should have known was improper, President Trump's personal attorney, Rudy Giuliani, traveled the globe in search of dirt on Mr. Biden and convinced the DOJ to open dedicated channels to receive this information. He did this to then U.S. attorneys Richard Donahue, East District of New York, and the Eastern District, and Scott Brady, Western District of, I don't know. I'm terrible. Sorry. And he made presentations to multiple U.S. attorneys' office regarding Mr. Biden. Since then, Mr. Barr has confirmed on the record that knowledge of how information was shared by Mr. Brady's team to the and just weeks before the 2020 presidential election, Mr. Giuliani obtained stolen electronic data from Mr. Biden and disseminated its purported contents, as well as manipulating some of it in an attempt to create a media spectacle and undermine President Biden's political campaign. Since leaving office in January 2021, Mr. Trump has continued to flex his considerable influence over government officials to drive the case against Mr. Biden and criticize the plea agreement between him and DOJ. For example, on March 31st, 2023, when Mr. Trump was notified charges had been filed against him in Manhattan criminal court, his response was to post on the inaptly named Truth Social, quote, all caps, where's Hunter? The following week, during an evening address at Mar-a-Lago, after 34 charges against Mr. Trump were unsealed and he surrendered and was arraigned, Trump's response was again to make wild accusations against, I guess that's Hunter Biden and his family. On June 20th, 2023, Mr. Trump posted repeatedly on Truth Social about the agreements that the DOJ had made with Mr. Biden and announced that day. Wow, this is a quote. Wow, the corrupt Biden DOJ just cleared up hundreds of years of criminal liability by giving Hunter Biden a mere traffic ticket. A system is broken. All caps. A sweetheart deal for Hunter and Joe as they continue their quest to get Trump, Joe's political opponent. We are now a third world country. And finally, well, not finally. And then, quote, the Hunter-Joe Biden settlement is a massive cover-up, these all caps, cover-up and full-scale election interference scam, the likes of which has never been seen in our country before. A traffic ticket, and Joe's all cleaned up and ready to go into the 2024 presidential election. On June 24th, 2023, Mr. Trump posted repeated false charges on Truth Social. Quote, when Hunter Biden harshly threatened the Chinese businessman, he and his father Joe were together in Joe's house. Even the ownership of the house and rent paid are questionable and now forgotten about by the fake news media, where classified documents having to do with China was stored. They took in millions of dollars from China. How much information was given? Big stuff. All caps. Joe's totally corrupt. Hi, Kim. Biden will do another one. Quote, Biden will do about Russia whatever President Xi of China wants him to do. What? Remember, Hunter and Joe illegally took large amounts of money from both countries, but China right now is the bigger threat. Mr. Trump has also reposted on his Truth Social channel libelous comments about Mr. Biden, including one on June 26, 23 that said, quote, American justice, 69-year-old grandma with cancer given more prison time for walking inside U.S. Capitol than Hunter Biden for sharing classified documents with foreign regimes and multi-million-dollar bribery scheme. Mr. Trump curtly captioned above the post, horrible, which Pam is the one he was talking about. And she responded, I guess, and said, nuh-uh, don't say that. She said horrible. And regarding Mr. Biden, And regarding Mr. Biden's deal reached with the Trump-appointed USAO in Delaware on July 11, 2023, Mr. Trump wrote on Truth Social, quote, Weiss is a coward, a smaller version of Bill Barr, who never had the courage to do what everyone knows what should have been done. He gave out a traffic ticket instead of a death sentence. That's terrible. What a terrible thing to say. On November 23rd, 2023, Mr. Trump posted on Truth Social, "Why would anybody be surprised that the Supreme Court has ruled against me? They always do. It is unprecedented to be handing over tax returns, and it creates a terrible precedent for future presidents. Has Joe Biden paid taxes on all the money he made illegally from HUNA and beyond?" DOJ kept Mr. Trump and, wait, what? DOJ kept Mr. Trump and his yes men at bay for years by continuing to investigate Mr. Biden, even as the investigation failed to reveal any serious offense. But the department's future, if Mr. Trump wins the next presidency, looks bleak. Mr. Trump's outrage at DOJ's failure to follow his demands is dangerously compounded as he fends off his own criminal and fraud charges, which do relate to national interests and presidential competency. At a recent political rally, he swore retribution on his political rivals and the agency he blames for helping them. Let's see if there's anything good in here. It is ironic. Let's see. This is Ryan Bort in Rolling Stone. It is ironic that Trump boasts that he only hired the best people, but now derides so many of his former administration officials because of their criticism of him. Oh, interesting. Interesting. Let's see. I think I missed. Oh no, that wasn't anything good in there. He promises he will, quote, defund the DOJ and FBI until they, quote, come to their senses and appoint a, quote, real special prosecutor to go after the Bidens and revive an executive order that allows him to fire executive branch employees without cause. These are not abstract promises of vengeance. Mr. Trump is literally describing how he intends to misuse his authority to punish and cripple DOJ for not locking up Mr. Biden. Thanks, Ted. In fact, even when directly asked on live television in a recent interview whether he would seek to use the powers of the presidency to get even with his political enemies, he could not even manage a denial. Instead, Mr. Trump claims he only plans to abuse his power on day one of his presidency, and no one familiar with Mr. Trump would lightly call his bluff. The prospect that Mr. Trump may be elected and turn his vengeance on the prosecutors if they fail to take a hard line against Mr. Biden and aid Mr. Trump's election hopes is surely not lost on them. Moreover, the fact that Mr. Trump now emphasizes his desire to seek retribution on Mr. Biden and others on his blacklist in the future undermines any contention that he was above abusing the powers of DOJ to target Mr. Biden in the past. I am your warrior. I am your justice. And for those who have been wronged and betrayed, I am your retribution. Boy, does that sound like Steven, I know. Has a video. We'll play it. We played it at the top. I'm going to play it again. It's such a good song. He did such a great job. It's really awesome. And the video's okay, I guess. President Trump initiated the investigation of Mr. Biden illegally. U.S. Code 26, Section 7217 provides, quote, "It shall be unlawful for any applicable person, including the president, to request directly or indirectly any officer or employee of the Internal Revenue Service to conduct or terminate an audit or other investigation of any particular taxpayer with respect to the tax liability of such taxpayer." Okay. Republicans and did I read all this? Yeah. Republicans in Congress. After President Biden assumed the office, more than 2 years after President Trump started calling on DOJ to investigate Mr. Biden, Senators Chuck, that's not my pigeon, Grassley, and Ron, I live in Wisconsin, Johnson, is sent letters to the Secret Service, the FBI, and the ATF, requesting all records related to the firearm purchased by Mr. Biden, a private citizen, and publicly announce their actions. Since then, congressional Republicans have used every excuse to criticize DOJ, publicly question its integrity, and threaten the agency with everything from subpoenas for documents and testimony to defunding and increased congressional oversight. In April 2021, 24 members of Congress, all staunch opponents of President Biden, wrote a letter to President Biden's nominee for the director of the ATF, calling on him to commit to investigating Mr. Biden if confirmed. Let's see what this big old footnote says. After unlawfully requesting that Mr. Biden be investigated, President Trump violated another code of the Internal Revenue Code by interfering with that investigation. The section has two substantive provisions. The officer clause forbids, quote, corruptly or by force, threats of force, including any threatening letter or communication, endeavoring to intimidate or impede any officer or employee of the United States acting in an official capacity under the Internal Revenue Code. Emphasis added. The second clause, the omnibus clause, forbids, quote, corruptly in or by force of threats of force, including any threatening letter or communication, obstructing or impeding or endeavoring to obstruct or impede the due administration of the Internal Revenue Code. Mr. Trump has done both. He's a fucking Nazi dictator. Yep. Well, and I want to talk about that. So put a pin in it, Kim, because I want to talk about that. I guess I'll just say it now. Listen, Trump is running for president so that he can pardon himself and get out from under all of the legal shit that is creeping into his orifices as we speak. Hi, basket package. I didn't see you sneak in. So to the point where, wait, what was I going to say? Oh, yeah. So Trump is really focused on like, he's a single issue guy right now. He wants to protect himself. While he will execute all of the bad ideas, he's not the focus of my sleepless night. The focus of my sleepless night is what I saw on stage yesterday at TPUSA. And if you haven't seen it, I actually would recommend terribly Steve Bannon's speech at TPUSA, Amfest, or whatever the fuck it's called. It's on YouTube. So it's the people around Trump who in the first term kind of tested the guardrails, right? So it tested the guardrails, but it's the people that will enter with him that now know how certain things work in the federal government to the point where they can further corrupt and bend them to support the following: privatization of all services, privatization of Social Security, destabilization of the dollar in the face of digital currency, privatization of policing, and further militarization of the police. Trump, in the last two speeches that I've heard, one of his new talking points is letting law enforcement do their job, quote unquote. I just want you to let that sink in. Okay? It is the deal making of people like Flynn and his cohort with foreign fuckwads that then further erode democracy in Ukraine, in Europe, in South America, in Southeast Asia. So where democracy has a chance or something, like they're trying to really like shut all of that down. And even I was reading something, was it this morning or last night? Oh, it was that stupid quote by Elon. So Elon to me is just saying all of the parts out loud that people like Peter Thiel and others consider, which is more babies because more workers, more production, more money. So it is what I have always believed is that the big scary plan is authoritarianism and the exercise of that, taking away rights such as Roe, going further, and that he has all the people around him who now know how to make those things happen. And I think that in some cases, it was just blind luck that it didn't happen in the first term. So the Overton window has been pushed. And I believe that when things start to actually, if it comes to pass that this administration, gets in, I have no doubt in my mind that you will see a rollback of rights like we have never seen. I mean, I'm not even trying to be scary. I'm just trying to think of what did they do in the first term and what was holding them back from doing more. On stage at AmFest, I don't know if it was every speaker, but I think it might have been. Every speaker brought up anti-trans hate and spewed it. So they have an enemy, and they will release their idiots to do further damage to the trans community, to all communities that they deem not worthy of having rights. Oh, sorry, my banner's bad. So it is not Trump Trump scares me. Of course he scares me because, whatever. It is the Lost Tapes. Oh, really? I haven't seen that, Kim. The Lost Tapes, Third Reich. Yeah, basket package. The pushing of protect the children, protect the children, protect the children. That's a war cry, right? The fact that I'm just trying to, my concern is the fact that what I listen to is the people who are on the ground, the chuds and the others, like the chicks on the right, who have, a smallish number of viewers, but their message is consistent with other right-wing, flows. And I just cannot recommend enough People You May Know, which is a documentary. It's available for, I don't know, $2.99, I think, is the rental on Amazon. I mean, fuck Jeff Bezos, who also, by the way, wants the population to grow. So my fear is a kleptocracy where social safety nets are eroded, rights are rolled back, public education is decimated. Oh my God, I'm sounding like one of those people. I don't want to sound like one of those people. But I do want us to be aware as to why. Yeah, okay. See, that's kind of a nicer version of what I'm trying to say. That's a more reasonable version of what I'm trying to say. I mean, he to me was the Trojan horse. And he has no interest in governing. He doesn't give a flying fuck all. He is singularly focused on getting out of his legal entanglements. That's all. That's it. Period. Full. End of subject. Stop. He wants to get away with what he got away with. And I don't want to stop talking about the binder of Crossfire Hurricane. This is why I think the Mueller investigation is going to come back. And the fact that no charging decisions were made on the Mueller investigation, I think that's going to come back. Oh, no, he totally loves to hurt people. Oh, I have no, that's part and parcel of it. That's part and parcel. But I'm saying from a what does the presidency give him? He doesn't care about being president of the United States. People laughed at him. He knew that. He knew people were laughing at him. He just wants the stuff that comes along with it. The adulation from those fucking maggots. You know, he loves the Mussolini. He loves it. But policy, he doesn't give a fuck what they do. Yeah, and why did so many requests for pardon? Yeah. There's the other thing. How about all these illegal pardons? Can we revisit those? Oh my god, I'm going to take a little smoky smoke. Anyway, these are the things I think about. I think it's time to go over the Mueller report again. God damn it. We might do that this week because I feel like this week is going to be slow from like a events category. But maybe it'll give us time to catch up. Oh no, please don't worry. My God, sorry for my speaking. Sorry for the way I speak. I kind of want to show you guys my shirt, but I don't have any makeup on. Maybe I'll do that. Because it says "Pray for Surf," and then it's got like a Madonna by a surfboard. I got it off of eBay for like $7. Wait, let me see if I can do it without showing you my face. Hold on. Let's be weird about this. Ah! Don't fall! Don't. That I said not fall. I said don't do it. Okay, hold on. I'm gonna make sure. Oh! Because it's really cute. Let's see. Let's do this. There we go. Oh yeah, you can't see my face. Whoops. In there. Pray for Sir. And then she's praying by a surfboard. I don't know what else is on there. I love it. It was $7. That's so great. What's the deal, man? That's a deal. I cut it though. I cut all my shirts. I'm a shirt cutter. Just a big old shirt cutter. You're just a big old shirt cutter. It's cute. I love it. I don't know how I found it. I usually just look for the cheapest old shirts I can find. That's what I do. Okay. All right. Come on. We got to get back to this. Get back to this. Silly girl. All right. Here we go. Here we go. Here we go. Here we go. Keep going and you'll have a nice vest. It's not a thunder vest though. All right, let's see. Where did we leave off? Okay, that we talked about that. Okay. This is still talking about Congress. In June 2022, when asked by reporters about gun legislation and recent mass shootings, Senator Johnson used the opportunity to publicly call for prosecution of Mr. Biden. The House Oversight and Accountability Committee's, quote, mission statement is to ensure the efficiency, effectiveness, and accountability of the federal government and all its agencies, end quote, not to investigate a private citizen for crimes it has a political motivation to uncover. Yet it has teamed up with the House Judiciary Committee to malign DOJ and subject the agency to burdensome inquiries while incrementally second-guessing its investigative and prosecutorial role. Rep. Comer regularly goes on media outlets to condemn what he mischaracterizes as the Biden crime family and brag about misusing congressional authority to conduct its own criminal investigation of a private citizen. In a recent committee press release titled, Justice Department Attempting a Biden Family Cover-Up, Rep. Comer vows, the House Oversight Committee will continue to follow the Biden family's money trail and interview witnesses to determine whether foreign actors targeted the Bidens. President Biden is compromised and corrupt, and our national security is threatened. Where's the binder, Jim? We will also continue to work with the House committees on Judiciary and Ways and Means to root out misconduct at the Justice Department and hold bad actors accountable for weaponizing law enforcement powers. Sure will. Here we go. My family's from the South. Don't Fight me. Days later, this is a footnote. Days later, Mr. Giuliani, now under criminal prosecution himself, will play his song momentarily. Further push for the prosecution of Mr. Biden for possession of a firearm on Fox News. Tucker Carlson tonight. The reality is, the hard drive spells out, as we know, a clear violation of the gun act. The application is straight out fraud. He says, I'm not an addict. We have a picture of him 5 days before, smoking a crack pipe behind the wheel of a car, and then saying under oath he's not an addict. Letter from U.S. House Representatives to David Chipman. This conduct is particularly troubling, given that such an investigation is well outside ATF's normal course of practice when addressing similar conduct. All right. Okay, wait, where am I going? Oh, yeah. In other words, multiple Republican-led House committees have taken it upon themselves to investigate Mr. Biden for criminal activity, while criticizing DOJ's exercise of prosecutorial discretion in not bringing more serious charges against him, stoking public and political outrage and distrust of the agency, and directly interfering with DOJ's investigation by subjecting it to a burdensome congressional inquiry. And unlike DOJ, Congress does not even pretend to offer Mr. Biden the presumption of innocence. Now, Rep. Marjorie Three Toes claims Rep. Jimmy Comer is, quote, leading the best investigation into the Bidens, far better than anything the FBI has done, far better than anything the DOJ has done. In Rep. Jordan's own words, the fix is in. But Republican-led House committees are doing the fixing, and Mr. Biden is the victim, the Department of Justice. DOJ confirmed its own improper motive when, under fire from Congress and the public, it resorted to a rarely used gun charge that reports indicate Special Counsel Weiss himself admitted would not have been brought against the average American. That's right, because he said it. As noted above, the article does not disclose the source, and to the extent there is any doubt about the veracity of the claim, the court should grant Mr. Biden's request for discovery and an evidentiary hearing. Yes, that's what we're asking for. That is an admission of an improper motive. In Bradley, 1994, quote, circumstantial evidence of invidious intent. Invidious, oh, I love it. May include proof of disproportionate impact. Mumphrey, 2016 says, evidence of differential treatment is also probative of discriminatory intent. Well, you know, I just love a good probative. That's what I love. I'm waiting for my next probative. Appropriate factors considered by prosecutors in making charging decisions include the strength of the case, the prosecution's general deterrence value, the government's enforcement priorities, and the case's relationship to the government's overall enforcement plan. If DOJ had wanted to bring the gun charge based on any of these legitimate considerations, it would have done so years ago when it first became aware of the relevant facts and before the statute was held unconstitutional. Falk had a prima facie case of selective prosecution where government had notice of the defendant's blah, blah, blah. Okay. But DOJ did not, which makes sense because DOJ's enforcement plan and priorities expressly state that agency resources in federal gun statutes should be reserved for prosecuting violent crime. In view of its admitted, this is a quote, in view of its admitted policy, it was incumbent upon the government to come forward with evidence that it had, in fact, changed its policy generally or otherwise to explain why Falk was being singled out for prosecution in contravention of the government's own procedures. Whoa, it's got some case law behind him. Instead, even when DOJ did cave to political pressure and decided to do something about the gun charges, prosecutors were willing to resolve the whole matter through a non-prosecution, later a diversion agreement without a guilty plea before IRS whistleblowers went public, and the pressure they generated caused the agreement to become politically unsavory for the Republican prosecutors. Indeed, some circumstances may for all. Okay, that's fine. And if there were any remaining doubt, only then did Mr. Weiss demand that Mr. Biden plead guilty to misdemeanors, dismissing charges because the court was, quote, forced to conclude that the prosecution was seeking convictions at the expense of justice. And if there were any remaining doubt about DOJ's improper motive, DOJ's efforts to torpedo even that plea deal in response to political blowback puts the matter to rest. Even if DOJ could claim with a straight face to have brought charges and agreed to a deal based on legitimate considerations, Nothing about the court asking the parties to address certain concerns with incidental mechanics of the plea agreement structure should have impacted that analysis. No issue was raised by the court as to the fairness of the plea agreement, only as to whether the mechanics would secure Mr. Biden the benefit of his bargain in the event that the prosecution alleged a breach of the agreement and the role of the court in the diversion agreement, a demonstration of this court's respect for separation of powers that the other branches of government lack. What changed were the political consequences for the prosecution following Republican criticism in Congress. And this led DOJ to abandon a deal it had emphatically recommended that the court accept as a fair and appropriate resolution of the case hours earlier. Indeed, rather than respond to the court's questions in writing, as the court requested, the prosecution simply withdrew the plea agreement, which easily could have been tweaked to address the court's concern. When the prosecution purports to act in accordance with its legitimate enforcement priorities and then does a 180-degree about-face in response to congressional ire and criticism, particularly absent any change in the prosecution's understanding of the facts or a change in the law. Here, of course, there was a change in the law, but one that cut against prosecution. Improper motive is evident. Prosecution improper if, quote, the government had legitimately determined it not to prosecute appellant and then had reversed its position solely because he filed a complaint, close quote. Quote, the government did not change its view of the merits, it merely sought to avert the risk of rebuke, close quote. And whether DOJ did so at the urging of public officials in pursuit of the prosecutor's own political agenda or to fend off criticism and avoid scrutiny, discriminatory purpose is at the heart of this case, and it must be dismissed. Holding that government acts with, quote, discriminatory purpose when it selects or reaffirms a particular course of action, at least in part because of, not merely in spite of, its adverse effects upon the accused. Crowthers in 72 says, what the government has done here is to undertake to suppress a viewpoint it does not wish to hear under the guise of enforcing the law. Bam, bam, First Amendment activities. Nothing can corrode, this is from Barrios. Nothing can corrode the respect for a rule of law more than the knowledge that the government looks beyond the law itself to arbitrary considerations such as desire to discipline political foe and the dissident. This is a good argument, I think. Prosecution of Biden has discriminatory effects to establish a discriminatory. Okay, just a minute. Take a drink. Okay. To establish discriminatory effect, a defendant must show that similarly situated individuals were not similarly prosecuted. To establish a discriminatory effect, a defendant must produce some evidence that similarly situated defendants could have been prosecuted but were not. It is hard to imagine better evidence than the report of the special prosecutor Weiss's express admission that he did not want to bring these charges against Mr. Biden because DOJ would not bring them against the average American based on the same facts. Several experienced legal experts and law enforcement officials have agreed with Special Counsel Weiss's initial conclusion that prosecution is not warranted. Even with respect to the tax charges that were just brought in California, former Attorney General Eric Holder stated on live television that he had spoken to both Republican and Democratic U.S. attorneys, and all agreed that the charges would not have been brought but for political pressure. This supports an interference of discriminatory effect. From Adams, Mr. Gibson, drawing on his lengthy experience as an employee of the IRS, states in his affidavit that he does not believe criminal proceedings would ordinarily be instituted in tax cases of the sort presented here, which raises a significant question as to why this particular prosecution was undertaken. In Falk, the unrefuted evidence before the court, including the admission of the Assistant United States Attorney and the two published statements by the Selective Service officials that can contradict the propriety of the action taken in this case, made out at least a prima facie case of improper discrimination in enforcing the law. All right, this is a New York Times article. The gun charges against Hunter Biden are unusual. Here's why. From September 2023. Quote, when officials with the Federal Bureau of Alcohol, Tobacco, and Firearms and Explosives reviewed Hunter Biden's gun application several years ago, they believed the case most likely would have been dropped if the target were a lesser-known person, because the gun had not been used in a crime, and Mr. Biden had taken steps to get and stay sober, according to a former law enforcement official familiar with the situation. The accuracy of Special Counsel Weiss's alleged acknowledgement that an ordinary citizen would not be prosecuted for this offense is borne out by policy and statistical evidence. 922 of the DOJ is very broad, covering millions of gun owners who use substances controlled under federal law, including marijuana, even if those drugs are legal at the state level, yet they are almost never used. In the years 2008 to 2017, for example, of the 132,464 criminal prosecutions under federal gun statutes, only 1.8% were brought under Section 922. Similarly, with respect to Sections 922 and 924, the GAO has reported that the DOJ rarely even investigates, let alone criminally charges, individuals who falsely deny drug use or addiction when purchasing a firearm. Fewer than 1,000 such cases each year are referred for investigation. And even when they are charged, it is typically done in conjunction with a more serious crime, such as the use of the unlawfully obtained firearm in a violent crime. Purchasing firearms for others who cannot purchase, I'm imagining, legally purchase them, possession of firearms with extended clips or obliterated serial numbers, drug trafficking, etc. Let's see, what does this say? This is a Newsweek article. There's an estimated 81 million Americans ages 18 and over who own a firearm, and more than 20% of gun owners have admitted to using drugs, even on surveys relying on self-reporting. In Newsweek, that means that by conservative estimates, at least 16 million Americans could be subject to criminal prosecution under 922 for the exact conduct of which Mr. Biden is accused. Interesting. Recent government estimates that nearly 60 million people in the United States use illicit drugs each year, and around 25 million struggled with the substance use disorder in the past year. This is the U.S. government, the GAO, Government Accountability Office. It's a report, September 2018. Fewer than 4,000 delayed denials were even referred for investigation because the owner was an unlawful user or addict. Okay. Beep, beep, boop. DOJ's selective enforcement would, of course, be arbitrary and capricious unless it is choosing who to charge based on legitimate enforcement objectives. In Cox v. Louisiana, it is clearly unconstitutional to enable a public official to engage in invidious discrimination among persons or groups by selective enforcement of an extremely broad prohibitory statute. Criminal charges are meant to punish disfavored conduct, not people who may be disfavored by prosecutors. Ooh, sick burn. Seems like an important precedent. Criminal charge, blah, blah, blah. There are, however, no distinguishable legitimate prosecutorial factors that might justify making different prosecutorial decisions with respect to Mr. Biden and the millions of other nonviolent offenders whom DOJ does not prosecute. We can say this with confidence because, beyond the powerful statistics reflecting enforcement decisions, DOJ has defended its reluctance to bring these charges in articulating what it believes those legitimate prosecutorial factors are as part of its enforcement policy and practices. Those policies expressly reserve agency resources in federal gun statutes, including the one in this case at issue, to cases involving violence and public safety. In 2017, right before the time President Trump began bullying the DOJ to investigate Mr. Biden, Attorney General Jeff Sessions directed the DOJ to use the statute to prosecute criminals for significant violent crime as part of DOJ's Project Safe Neighborhood. Let's see. The denial cases generally include aggravating circumstances. Okay, that's aggravating circumstances and drugs. Okay. Later in 2021, a similar memorandum from the Deputy Attorney General's office further explained that, quote, the department is most effective when we focus our limited enforcement resources on identifying, investigating, and prosecuting the most significant drivers of violent crime. To that end, DOJ must, quote, focus more on ensuring the law enforcement intervention is aimed at the most significant drivers of violence and not aimed at enforcing particular statutes or bringing specific criminal charges. Quote, the fundamental goal of this work is to reduce the level of violence in our communities, not to increase the number of arrests or prosecutions as if they were ends in themselves. Quote, the department will focus on enforcement efforts on reducing the incidence of guns used to commit violent crime, as well as solving more gun-related violent crimes. To its credit, apart from this case, DOJ does appear to exercise its enforcement authority consistent with its PSN program. A review of DOJ Section 922 press releases for prosecutions under the statute show it is used when there are aggravating factors creating risk to public safety, such as violent crime, association with dangerous criminals or hate groups, drug or weapon trafficking, etc. Indeed, DOJ notes in every press release that the prosecution under Section 922 was part of the PSN program, quote, to reduce violent crime and gun violence, consistent with the department's, quote, violent crime reduction strategy. Yeah. Okay. Oh, look at this. Oh, I'm not going to read all that. Wow. It's the footnotes are doing some heavy lifting. Hi, butterflies. No problem. This is a good, like, I got to take a nap this afternoon. I think I'll put on Lolo. Because really, I'm just reading to you. And the cats have not participated at all. And I'm very disappointed. I'm going to be giving them some discipline later and giving them like a timeout because they didn't perform. I'm a stage mother. But then there is Mr. Biden. The unfortunate truth is that the DOJ lacks the resources to prosecute even a fraction of dangerous acts of gun violence. Yet DOJ devotes its limited resources to charging Mr. Biden, who purchased a single small revolver that he never loaded or fired and owned for just 11 days. One Scaramucci. Has no criminal record or history of violence. Has never posed a risk to public safety. DOJ is supposed to be evaluating the best way to build or maintain trust and legitimacy, to set strategic enforcement priorities, and to measure success by the actual reduction in violent crime. Prosecuting Mr. Biden undermines DOJ trust and legitimacy, and it certainly does nothing to reduce violent crime, which is undoubtedly why DOJ declined to bring charges for years. And even when it did so under political duress, it was willing to avoid prosecution through a non-prosecution agreement, and then, only after political pressure, a diversion agreement. Falk. In view of its admitted policy, it was incumbent upon the government to come forward with evidence that it had in fact changed its policy generally, or otherwise to explain why Falk was being singled out for prosecution in contravention of the government's own procedures. In Haggerty, the government's failure to follow its normal prosecutorial procedures mandates stricter judicial scrutiny of the prosecution. These facts support an inference of a discriminatory effect. Discriminatory text should include consideration of the goals of the prosecution program and even under the government's purported criteria for prosecution, for example, history of drug dealing, strength of the evidence, defendants have demonstrated that there were similarly situated defendants who were not arrested and subject to prosecution. Evidence of knowledge or of other offenders, combined with the failure to arrest any of those offenders, gives rise to an inference of discrimination. In Duncan v. Perez, it is clear beyond dispute that any violation may have occurred was so slight and technical as to generally reserve for law school hypotheticals rather than criminal prosecutions. No one was hurt, and de minimis violations of this kind occur repeatedly and do not become the subject of criminal proceedings. Medrano v. Alley, the activity was peaceful, did not endanger public safety, yet defendant's violation was treated differently from other violations, which were more serious in nature, which can only be characterized or biased as selective. Okay, so that's some great quotes. I'm sure I missed the most important one, but it's fine. Mr. Biden is not being singled out for prosecution for his conduct, the same conduct that implicates millions of other Americans who go uncharged. Rather, he is being singled out for his political affiliations and used as a means for Republicans to go after the president and promote their own political campaigns. He has established a prima facie case for selective prosecution, and the court need look no further than the record before it to see that DOJ cannot rebut this by, quote, proving that the decision to prosecute was free of discriminatory taint. Taint! The waters of justice have been polluted, and dismissal is the appropriate cure for pollution in this case. All righty. How are we doing? Oh, we're doing great. We're going to get through this whole damn thing. Oh, great, Paul. I think being the background is really cool. Vindictive prosecution is a species of selective prosecution where an accused must prove by a preponderance of the evidence that, 1, the prosecutor harbored genuine animus, and 2, absent this motive, defendant would not have been prosecuted. This can be done in one of 2 ways. Present objective evidence that a prosecutor's action were designed to punish him or her for asserting his or her legal rights, which is proof of actual vindictiveness. Or 2, to show sufficient facts to give rise to a presumption of vindictiveness, which may be overcome by objective evidence justifying the prosecutor's actions, i.e. discovery. An important difference between this claim and the one for selective prosecution is that a presumption of vindictiveness may apply even absent proof of improper motive, where there exists a realistic likelihood of vindictiveness. The vindictive prosecution doctrine reaches all prosecutions that pose a realistic likelihood of vindictiveness, whether or not the prosecutor acted out of vindictiveness, in fact. That's from another case. Prosecution is vindictive when the prosecutor acts on his own animus or was prevailed upon to bring the charges by another with animus. Well, hello. In Mansour, where an outside party in some way prevails upon the prosecutor in making the decision to seek an indictment, the ill will, whoever its bearer, may be imputed to federal prosecutors. Evidence that party had instigated and pushed the prosecution and supported claim that Alvarez. Okay, blah, 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 blah. Let's see. Where am I? Oh, sorry. Okay, quotey McQuotesters, quotey McQuotesters. The prosecution is laden with evidence, and Mr. Biden is defending himself against these charges because of self-serving and vindictive motives, ranging from a desire to punish him and others for engaging in constitutionally protected speech and political activity, to influencing elections, avoiding scrutiny and criticism, and other interests unrelated to the fair administration of justice. Mr. Trump's animus, his anus, for example, is beyond question, and he is happy to substitute it for due process. Indeed, while Mr. Trump rails against his own treatment at the hands of justice, he promises to use the same methods to exact his revenge if he ever returns to office. Such threats clearly evince vindictive motive. From Belsakal, in addition to mere appearances, this proceeding involves an explicit threat, the gravamen of which is an intent to retaliate. Mr. Trump's supporters and other opponents of the Bidens have their own animus and influence over DOJ, and they are actively targeting Mr. Biden based on his familial and political affiliations. Affiliations? Affiliations. And to seek retribution for actions taken by the administration and Democratic Party. These officials are not doing so in secret. They are publicly calling on DOJ to target Mr. Biden, remonstrating DOJ for reaching a plea deal and claiming credit for derailing it, and pressuring DOJ into prosecuting charges it initially found unwarranted. What does this say? In public, this is from Washington Post, Isaac Arnsdorf, Trump and allies plot revenge, Justice Department control in a second term. In public, Trump has vowed to appoint a special prosecutor to go after President Biden and his family. The former president has frequently made corruption accusations against them that are not supported by available evidence, right? Bank statements are not evidence. Even if there were, here we go. Even if there were no evidence of actual vindictiveness, that's not an easy word. A presumption of vindictiveness clearly arises from the facts of this case. Often such a presumption arises after a defendant successfully challenges a conviction, and the prosecution responds by bringing additional or more severe charges. But a presumption of vindictiveness may also exist in the pretrial context where, as here, the prosecution's actions create, quote, the apprehension or appearance of prosecutorial vindictiveness, such as when the prosecution ups the ante without legitimate purpose. The prosecutorial, this is from Velskal, prosecutorial vindictiveness doctrine prohibits the prosecutor from acting out of an actual retaliatory motivation or acting in a manner which instills defendant an apprehension of retaliatory motivation. DOJ obtained the facts underlying this case years ago, and it was satisfied that the case did not warrant prosecution. It was then planning to avoid charges altogether until IRS whistleblowers went public, generating Republican fervor, and Mr. Weiss suddenly demanded that Mr. Biden plead guilty to misdemeanor tax charges and a diversion agreement on the gun charge. Then, after agreeing to defer the gun charge as part of the diversion agreement, DOJ upped the ante again when that agreement and the plea agreement were criticized by bringing additional felony gun charges for the same conduct immunized by the diversion agreement. Vindictive prosecution where charges brought to avoid a problem the government feared would breed contempt for federal law enforcement. And just last week, DOJ upped that ante one more time by turning a 2-page, 2-count late filing paying information into a 56-page, 9-count tax indictment, which members of Congress again admit they pressured the agency into bringing. These facts fit comfortably in the mold identified by the courts as supporting an appearance of vindictiveness that violates due process. The cases that have found this relied on 2 key factors present here: suspicious timing of charging decisions and absence of delay in bringing charges and proximity to an event that appears to have triggered the decision. And 2, absence of any obvious legitimate explanation for the action. In North Carolina v. Pierce, for example, the Supreme Court explained that imposing a sentence to punish the exercise of legal rights is unconstitutional. And, quote, since the fear of such vindictiveness may unconstitutionally deter a defendant's exercise of the right, due process also requires that a defendant be freed of apprehension of such a retaliatory motivation. I just can't say that word. The court extended the prophylactic rule of Pierce to prosecutorial charging decisions in Blackledge v. Perry, noting that it would clearly be a different case if the state had shown that it was impossible to proceed on the more serious charge at the outset. Here, no new facts came to light after the prosecution executed the diversion agreement and proposed the plea agreement. It was simply a political pressure that drove the prosecution's decision to renounce the diversion agreement and add charges. Here, the DOJ did over what it believed it had already done correctly, simply because Republicans pressured the agency into being more hostile to Mr. Biden before the election. Mr. Weiss was subject to blistering political criticism, and there is no avoiding the appearance that he caved to this improper pressure. This fits the definition of vindictiveness. He upped the ante now 3 times in response to those directing animus at Mr. Biden and a desire to punish him and his family for lawful and constitutionally protected political activity. The timing of these acts and the fact that they were not based on new facts or circumstances create an objective appearance of vindictiveness, as the court explained in Velsikal. When, as in this case, the government chooses not to lodge charges for a period of time and then makes the decision to prosecute so close after a defendant elects to exercise his rights in the face of prosecution opposition, apparent vindictiveness is clearly established. Indeed, the question of the delay and the timing of the present indictment is crucial. The present Velsikal indictment alleges criminal conduct completed by 1976, and the basis of proof of evidence were materials in the government's possession since February 1978 at the latest. On the basis of these facts, the court finds that defendants have made a strong prima facie showing of prosecutorial vindictiveness or apparent vindictiveness based on the delay prior to the return of the indictment. The court must conclude that the government had the necessary evidence several months before filing new charges, but it chose to pursue those charges only when Velsikal pled nolo contendere, no contest, is that what that is, to the misdemeanor information. I could be a paralegal. Oh, they kicked you? Oh, the J6 space. Oh, those people are too much. Will it ever die? Will it ever die? Will it ever die? A charge increase might, in some circumstances, be justified by intervening events or by new evidence of which the government was excusably unaware at the time of the first indictment. But since this record is devoid of any illumination of the reasons why the first-degree murder charge was brought, we can only conclude that the re-indictment of appellants for first-degree murder denied them due process and that their convictions of that charge cannot stand. This court's sister has done the same. See United States v. Corey. Quote, the government has identified no new evidence, no new witnesses, and no change in the law to support this charge. The government's failure to provide an explanation for upping the ante only lends support to defendants' claim of vindictiveness. Well, upping the ante is the phrase of the day. As discussed, while many vindictive prosecution cases involve retaliation for specific actions by the defendant, the crux of the doctrine is that prosecutors up the ante after having exercised their prosecutorial discretion in response to improper motive. In all of these cases, that inference rose because 1, the timing of the charging decision was suspect, and 2, there was no change in circumstances or other reasonable explanation to explain the change in position. Same is true here, and this supports applying a presumption of vindictiveness in this case. DOJ did not bring the charges based on newly discovered evidence. It had the information for years, far longer than the delay of months that created the appearance of vindictiveness in several of the cases. DOJ then upped the ante from deferred prosecution to a guilty plea, and then again by withdrawing the deal entirely, both in direct response to political blowback. This is also not a case where the government is excusably unaware of new evidence supporting the subsequent charge, or a change in the law to support this charge. To the contrary, The only relevant change in circumstances between DOJ's assessment that prosecution was not warranted and its decision to bring charges was a ruling by the Fifth Circuit that found the statute unconstitutional. That should have further dampened the prosecution's appetite to charge this case. Yeah. The prosecution cannot rebut the clear presumption that this indictment is the product of a changes. Third typo in action caused by extraneous considerations that include who Mr. Biden is, who he is related to, and his political affiliations. These charges would not otherwise have been brought against him, just as they are not brought against millions of other similarly situated Americans, and just as DOJ implicitly acknowledged when it chose not to prosecute him sooner. Mr. Biden is not being prosecuted for any sin that DOJ believes he has committed. He is being punished for the perceived sins of his father, the sin of opposing Mr. Trump's election to the presidency. The prosecution of Mr. Biden violates separation of powers. On July 26, 2023, this court, noting that the executive branch has the discretion to bring charges, asked the parties to address the constitutionality of the role proposed agreement contemplated for the court. While the agreement did not contemplate an improper judicial role, which the parties would have explained if DOJ had not succumbed to political pressure and scrapped the deal. I think that's the fourth typo. The court was right to respect separation of powers and the integrity of the executive branch. The legislative branch, however, has failed to do so. The separation of powers has long been recognized as part of the federal constitutional system, quoting Martis. As the Supreme Court explained, quote, persons entrusted with power in any one branch of government shall not be permitted to encroach upon the powers confided to the others, but that each shall, by the law of its creation, be limited to the exercise of the powers appropriate to its own department and no other. Kilbourne v. Thompson. The doctrine of separation of powers remains a vital and important limitation on government, a limitation the courts have readily enforced. And Martis, the hydraulic pressure inherent within each of the separate branches to exceed the outer limits of its power, even to accomplish desirable objectives, must be resisted. And finally, Morrison v. Olson. We have not hesitated to invalidate provisions of law which violate this principle. Oh, no, not finally. In New York v. United States, the separation and independence of the coordinate branches of the federal government serves to prevent the accumulation of excessive power in any one branch. You heard it here. The Constitution's division of power among the three branches is violated where one branch invades the territory of another. Okay, this is a lot of great quotes. Yet, Congress is interfering with the executive function and DOJ is capitulating rather than fulfilling its obligation to maintain independence when exercising prosecutorial discretion. In fact, this exact situation was predicted by the Supreme Court in the context of congressional interference with state government. The court observed that, quote, it is likely to be in the political interest of each individual official to avoid being held accountable to all the voters, and if a federal official is faced with the alternatives of making a choice with potential political consequences or directing another branch to do it, the official may well prefer the latter as a means of shifting responsibility for the eventual decision. The interests of public officials thus may not coincide with the Constitution's intergovernmental allocation of authority. The court explained why the judiciary must guard against this outcome. Some truths are so basic that, like the air around us, they are easily overlooked. Much of the Constitution is concerned with setting forth the form of our government, and the courts have traditionally invalidated measures deviating from that form. The result may appear formalistic in a given case to partisans of the measure at issue, because such measures are typically the product of the heir's perceived necessity. But the Constitution protects us from our own best intentions. It divides power among sovereigns and among branches of government precisely so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day. The shortage of disposal sites for radioactive waste is a pressing national problem, but a judiciary that licensed extra-constitutional government with each issue of comparable gravity would, in the long run, be far worse. And it does not matter that DOJ has acquiesced. Quote, the constitutional authority of Congress cannot be expanded by the consent of the governmental unit whose domain is thereby narrowed, whether that unit is the executive branch or the states. Boumediene v. Bush. Quote, the framers' inherent distrust of governmental power was the driving force behind the constitutional plan that allocated powers among the three independent branches. So this is a lot about separation of powers. Separation of powers. Separate them. Don't let them get together. Yeah. Hey, Siegfried. How are you? In considering, after I finish reading this, I'm going to play the new hit from Oomph. And the video is an Oompflo production, and it's going to be great. In considering whether the doctrine of separation of powers has been violated, the courts are called upon to apply a sophisticated system of checks and balances designed to safeguard the structural integrity of a tripartite government. The Sixth Circuit affirmed on the facts of the case a ruling by the Western District of Tennessee that efforts by a member of Congress to influence DOJ's charging decisions did not breach separation of powers. What? On the fact, ruling by. Oh, affirmed. Okay. The efforts by a member. Okay. The court explained that because the object of the doctrine is nothing less than the preservation of political liberty, courts must not easily dismiss concerns that one branch of government has impermissibly encroached upon or diminished the powers of another. However, the court explained that, quote, generally, informal legislative pressuring of the executive for certain action, particularly from a lone legislator, does not itself result in any assumption of executive power or in legislative domination of the executive. Limitations on contact by members of Congress typically arise from the Administration Procedure Act or the requirements of due process, rather from concerns specific to the Constitution's separation of powers. But while the court agreed that public officials, quote, may cajole and exhort with respect to the administration of a federal statute, separation of powers are violated when those efforts, quote, result in an assumption of an executive power or in legislative domination of the executive. Don't dominate your executive. As an example, the court noted that the Supreme Court considers bills of attainder, where Congress seeks, quote, to compel a certain result or seeking to directly impose a punishment or penalty, implicates separation of powers. In United States v. Brown, the court determined that in that case, quote, the allegations against Congressman Cohen amount to nothing more than contentions that he cajoled or exhorted. Okay. Here, however, the scale tips the other way. A lone congressman is not just cajoling and exhorting. Many members of Congress, including the last Speaker of the House, probably the current one, Chairman of the House Oversight Committee, Chairman of the Judiciary, Chairman of the Ways and Means, are actively interfering with the DOJ's investigation, using their authority to pressure and malign DOJ, and using congressional committees limited to investigating government agencies to conduct a criminal investigation of private conduct by a private citizen, one they are conducting based on a publicly stated presumption of guilt. They have gone as far as releasing agents' entire investigative file during the investigation. Their actions have overcome Special Counsel Weiss's independent judgment, causing him to abandon the very resolution of the case that he proposed prior to their pressure. As noted above, these Republican House members have publicly claimed credit for causing Special Counsel Weiss to cave under their pressure. There was no such evidence in Martis. Finally, it is notable that by succumbing to congressional influence, DOJ is violating its own policies as well as being a party to a Hatch Act violation. See the Section 5 discussing longstanding DOJ policy against congressional interference. As DOJ explains on its website, all Department of Justice employees are subject to the Hatch Act and that other one, which generally prohibits department employees from engaging in partisan political activity while on duty in a federal facility or using federal property. Political activity is activity directed toward the success or failure of a political party candidate for partisan political office or partisan political group. Further restricted employees are held to stricter rules and may not campaign for or against candidates or otherwise engage in political activity in concert with a political party, a candidate for partisan political office, or a partisan political group. Considering the department's mission, it has been determined that, as a matter of department policy, all political appointees will be subject to the rules that govern further restricted employees under the Hatch Act to ensure there is not the appearance that politics plays any part in the department's day-to-day operations. What's this footnote say? Because the Congress There is no difference between prejudicial publicity instigated by United States through its executive arm and publicity instigated through its legislative. Pretrial publicity originated in Congress, therefore, can be attributed to the government as a whole and can require postponement or other modification of the prosecution on due process grounds. Good point. Okay, little drink. Sorry. Hold on. Woo! Woo! Right. We're getting there, man. Wow. We're reading this whole massive motherfucker. Boo, 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 boo. See also the August 30, 2022 memorandum for all Department of Justice career employees. Quote, the public trusts that we will enforce the laws of the United States in a neutral and impartial manner without the actual or apparent influence of political agendas. Memorandum for non-career employees. In fulfilling this responsibility, we must do all we can to maintain public trust and ensure that politics, both in fact and appearance, does not compromise or affect the integrity of our work. I know you agree it is critical that we hold ourselves to the highest ethical standards to avoid even the appearance of political influence as we carry out our department's mission, or the department's mission. The court was careful in considering the plea agreement and This court was careful in considering the plea agreement to respect DOJ's autonomy and discretion, but the court must not let judicial perfection be the enemy of the good. The prosecution's conduct here, quote, renders the interest in non-interference with prosecutorial discretion minimal and subordinate to Mr. Biden's right to non-interference with his, quote, constitutional liberty, or end quote, constitutional liberties. Sorry. The government's, this is another quote from Haggerty. The government's failure to follow its normal prosecutorial procedures mandates stricter judicial scrutiny of the prosecution. Another quote from Falk, the judiciary has always borne the basic responsibility for protecting individuals against unconstitutional invasions of their rights by all branches of the government. Congress has intruded on the executive function to an extent that only dismissal of these charges can cure, and DOJ has abdicated its responsibility and pledged to prevent it from doing so. The court should not hesitate to step in and safeguard Mr. Biden's rights, the independence of purity of government, and the integrity of the justice system. Here we go. We're going to end it with a really big quote. Quote, our society is not bettered by law enforcement that is not conducted in a spirit of fairness or good faith. Banks. This prosecution fails in that category, and the court should dismiss the motherfucking indictment. Bitches. These are all like whatevers. What's this? I certify. Oh my God, we made it through the whole goddamn document. Yeah. Oh my God, I gotta mute for a minute. I gotta cough. Can you hear me still when I mute? Oh, my tummy's growling. Back. Let's have some weed. Where'd you go? Did you have work? Or is there a better show on TV? Is there a cuter show on TV? I'm just kidding. Oh my God, that was a marathon. That was 69 pages of reading. Okay, thanks. Yeah, let's have some weed. Oh, let me put on the music. Hold on. Let me put on the music. What's this? Everything a little bit better. Oh, wait, no. First, I'm not going to play this yet. Hold on. Wait, I want to play the video. The new video from Oompflow. I'm telling you right now. I did the video, so the music is 100% oomph, and it is by fucking By fucking Hold on. Present, share screen, and this is what I'm gonna share. Brother, can you spare? This is the amazing song, Brother, Can You Spare? Brought to you by Oompflow. Vocals and music, all by Oomph. Video by Lolo. Enjoy. And I'm sorry, my replay does not do it justice, so I will link it in the chat again. And I want you to go watch it.
I was a New York U.S. attorney fighting organized crime. Now I'm a Roger Stone type fixer. How hard could it be? Brother, can you spare a dime? Once when I was mayor, 911, I preened on all the nation's TVs. Now I spend my time in court getting it done. Brother, can you pay my legal fees? Once with heads of state, bravely in parentheses, buffeted with the president's friends.
Stupid, dumb.
Gambled their licenses.
I like his tone.
I was the one in defense. Say, won't you believe me? I have the proof. You can count on guys like me, always. Tune into my podcast, you'll see it soon. Till then, brother, can you spare $148 million?
I love it. I love it. I love it. That's so good. That's really good, Oomph. That's really good. You're a really good musician. I know. I need to stop saying that and just like leave you alone. Oh, wait. Let me. There we go. Let's do it even lower. There we go. Oh, well, that's just me in a car wash. That was just me in a car wash. Because I'm like, oh man, this car wash is awesome. I gotta film this. I do that all the time. I film stupid stuff. Anyway, but the song is the lyrics are great. The voice is great. The playing is great. The percussion is great. I really like the percussion. All right, I'm gonna share this because we're gonna like chill for a minute. All right, present. What am I doing? What am I doing? Oh, there's an extra camera there. Good. Okay. Hold on. And then what I want to do is I want to still play it. Oh, I know. I need to do this. Can you still hear the music? Oh, thank you, Siegfried. Yeah, I also happen to have way too many pictures of fucking Rudy Giuliani. That's a problem. Yeah, no, it's really good. Really? I couldn't. Oh well, I'm going to be honest with you. I'm not trying to, you know, make a thing about it, but well, I mean, you actually do know how to create, like, you know how to play instruments. I don't actually know how to play instruments. Oh yeah, that's what we wanted. That's what we wanted, Siegfried. Good. I'm glad. I know. Isn't it great? So good. So good. I'll tell you, I love that. Fucking that car wash video. I got to do some more shit like that where it's like a long, because that's like 6 minutes total. That's really good for GarageBand, because I cannot. I really um I really wanted to I really want to write my own music, but I really don't know how to do it. So there's that. Why is it so dark over there? Oh well. Yeah, I don't know how to do it. I mean, one of these days we're gonna figure it out and then do it. Oh, the brushes, yeah. Yeah. Super cool. Super cool. So cool. I love it. God, I just don't want to leave, but I guess I should. I guess I should let everyone get on with their day. It's kind of cool though, isn't it? I wonder if I just left this here for a while. Oh my God, I'm so sorry. Oh, like I'm on the very end of this cold. And it's like holding on like a motherfucker. Sorry, that was really gross. Your sister creates rave music and she never. You know, I used to do some DJ stuff where I would mash up songs. So I actually have a little bit of like, I just have basic knowledge about DJing. I don't even want to like say that too loudly because I'm an idiot. But you know what I think is that oh, thank you for the thumbs up on Facebook. I really appreciate that. Hello to all my Facebook viewers and on Democracy Dino and on Twitch. Twitchy. But I would love to. I've been trying to create music. A person with a different sort of mind could build a great EDM with nothing more than built-in loops. Well, you know, I mean, you could do it. I'm not. Uh-oh, here, we've got a cat sighting. Hold on, guys. I think we're going to get a cat. Hold on, I'm going to be quiet so the cat will move up to the tower. Hold on. No, you have to go up. Sammy, don't go to sleep there. All right. I wonder if I could point it down on Sammy. Hold on. Oh, so dirty. There's the cat. There, cat cam. I just pushed all the furniture out of the way in the living room. But I think they have taken over the beanbag. This beanbag is massive. It's such a great beanbag. I love it. That's right. That's Sammy Bam. Samwise Gamgee. Samwise Gamgee John Waters. That's who that is. His first name was, well, his first name I think was Stripes, but his first name was John Waters. Uh-oh. Did you see a bird? Did you hear a bird? But now he's it's not a beanbag. It's not a beanbag for cats. The dog sleeps on it too. Like it's a human. It's for humans. But let's watch him clean himself. That's great. I have that suitcase there so they can sit on it and look out the window. Go to the next one. I wonder if it'll just keep playing them. Oh, it does. That's cool. That's real cool. Okay. I know the things we do for cats. Well, I would kick him out of there. If I needed to sit down there, and I will be taking a nap on that later on, he's going to move over. Yeah, I said you. That's right. I'm talking to you, sir. You can ignore me all you want. This is great. I think this might be the best stream I've ever done. Oh my God, I gotta move some stuff. Get out. Then I can get out. Without, he's ignoring me. Yeah, and typical. He's a typical. Let me see if I can do this. My floor is really dirty. I don't really want to show you my floor. Actually, I kind of like it when there's a little bit of window. Oh, no, we can't do that. Okay. That's fine. We'll keep it on him. Sam, do you feel like someone's watching you? Hey, Samwise. Where's Gustafer? Let's get Gustafer out here. What the fuck are you do? Yeah, exactly. Why are you doing that? Why is the front of our cat condo blocked by this huge fucking beanbag? That's what he's saying to me. Look at Sam, Bobo. I have the camera on him. He's so cute.
So funny.
Oh, come here, Bug Papa. Big Papa, you want to be on camera? Come here. Come here. Come here. Come over here. Can you guys see Big Papa? Oh, you can see. Hey, oh, Papa, you got to get over there. Oh, he's not going to do
He's
it.
not getting on the same bag as
Oh, yeah, he's not going near that fucking fucking cat. That's right. Oh, yeah, he's clean. I know. The tail. He's so cute. He's 13. He didn't want to show you his face. I know. I will when he comes out. Look at Sam. Sam's like, that motherfucking dog better stay far away from me. Oh, animals. Oh, he's so cute though. I don't know how to I don't think this telephotos. I think it just like that. I don't think it does any telephoto. Wow, it's a Monday, right? Am I right? What else is going on? Anything going on the YouTube streets? Never mind. I might come back to Twitter. Although I'm enjoying Blue Sky. Can I tell you? I'm getting my groove on Blue Sky. And one of the things I hate about modern life is there's too many applications. I know. I'm afraid to find out what's going on. He is a bundle of love. Yeah, I don't really want to know. I mean, I do want to know. I hope. I think we are, Paulina. Let me check. Hold on. Let me check. I feel like I followed you. I don't. Well, no, I have. Oops. Are you the I am Paulina? Yes, I'm following you. You're following me too. Yay. Oh, 13. You guys are so nice. Thank you so much for sharing everything. MJ and Ted, you're so cool. Thank you so much. I appreciate that. Bump, bump. Bump, bump, bump. Bump, bump. Bump, bump, bump. Yeah, I know. Twitter is mentally draining. Oh, I miss everyone. I know. I have terrible FOMO. I'm always afraid I'm missing out on something. That's one of the things that was so hard about the convoy experience and how everybody just was so fake when you were in the groups with people and the way they're acting now. Although I did see that there is a major chaos agent that has infiltrated that group. So I don't know what to tell y'all, but you've been infiltrated by Pink MAGA. Yeah, she's full MAGA, but whatever. That's your deal. I just went ahead and block. I don't want to deal with you all. You all go do whatever you're going to do over there and leave me the fuck alone. I'm going to be here showing pictures of my cat and my dirty floor. That's what I'm going to be doing. And reading very long documents in funny voices. and mispronouncing words and really just running as fast as I can through some words so that I don't have a chance to linger. Your cat spends time outside. I used to, when I was very, very, very little, we had an outdoor cat, but I have not had an outdoor. I think it would stress me out too much. It would really stress me out too much. So, yeah. Anyway, and I'm going to continue to do my thing, and no one's going to stop me. And I am on the right side of history with this one. And the people who betrayed me, you're on the wrong side of history with this one. And I'm never going to let you forget it. And I'm gathering a lot of information. So don't sleep too well at night, folks, because your fuckery is about to come back and haunt you. But that's what happens. It's called FAFO. We talk about it a lot. Fuck around, find out. So that's all I'm saying. And I know you're going to get all upset about it, but I don't really care. Because I don't really care how you feel. Have you tried to let only the people you follow respond to your tweets? That's I don't even see, the thing is Paulina, I don't care about the insults. That's not it. It's the people that have betrayed me, that used to call me a friend and now act like nothing is wrong. Those are the people I don't want to see. Those are the people I don't want to see. The people who make it about them all the time, those are the people I don't want to see. The people who are fake activists, who get propped up by everybody because they are whatever, but they have zero substance and zero information without their team telling them what to do, where to go, and what to say. So I don't want to see those people. I don't want to see their fucking friends. I don't want to see their simps. So I try real hard to avoid them. And I will continue to do so. So, as a very wise friend said to me, everybody is on every platform. There's no need. So that's my new attitude, is I'm going to just do what I do. I'm going to keep doing my shit. I'm going to laugh at them. And I'm going to take a bunch of fucking screenshots. That's it, babes. Oh, by the way, congratulations. Oh yeah, no, there's a few Lolos, obviously. There's even some of those betrayers, some of those traitors to me, who now continue to hurt me and my daughter and my family by their mere continuing to promote lies, inexplicably. Those people, one of them's a member. One of them got swept up in the membership gifting. I hope he comes to the movie night. Good to see you're back. That's so cute. Yeah, so maybe he'll come to members night. I will be blocking those people from Discord, by the way. I'm not fucking around, so y'all can just kiss my motherfucking ass. Yeah, Discord's going to be pretty tight. Just because that's what they love to do. They love to go into Discords and use those as the way to kind of disrupt and instigate shit. And we're not those people. We're adults. And we don't do that shit. I don't use Discord for that. I don't do that. I'm not doing it. Because that's what it becomes inevitably. Unless you make a decision to be like, I'm not going to do it. And I've engaged in like stupid gossip. I'm not saying I haven't, but I just I'm paying for that. Karmically, I'm sure I'm paying for that. The other thing is that I also opened a Blue Sky for Democracy Dino. So there is no Democracy Dino that is affiliated with me on Twitter. There never has been. So someone is using a Democracy Dino to abuse other people. And yeah, exactly. That's what happened to Jim. They got in his Discord. Same people, actually. The same fucking people, crazily enough. So I have no intention of having them come to our doorstep. They can save it. Oh, I'm sorry, Siegfried. I'm so sorry. We're gonna. I hope we. I hate apps. I really do. But there is a Democracy Dino on Blue Sky. It's I think it's just Democracy Dino. Let me see. What's its handle? Here we come. Anyway, I'm actually not as angry about all this, but it is relatively recent. So that's the only reason I'm going over it. Believe me, all you nimrods out there listening or whatever, I don't really give a shit about you guys. You're just a pain in the ass, which is exactly what you want to be. So who cares? But I'm going to talk about it when it makes sense to talk about it. Oh, I see. I don't have Democracy Dino. Oh, wait. Democracy Dino is here. Here we come, walking down the street. We get the funniest looks from everyone we meet. Sorry, I know that's annoying. Okay, it's literally Democracy Dino, all one word, .bisky.social. Bisky. So you can follow Democracy Dino. I more did it so that I could protect Dino, because Dino was violated by a grown-ass man on Twitter for his own sick, perverted purposes and to abuse people and be bigoted. And obviously, that's not ours. And he doesn't even have all the pictures and everything. But he does have my link tree, which is really fucking weird, in his bio. Really fucking weird. But that's what these folks are. They're really fucking weird. And not in a good way. So, yeah, gotcha. But yeah, I'm excited. I actually am. I'll try to make them. You know what I miss about Twitter? I miss spaces. Isn't that terrible? I know, he's so cute. I miss. I miss spaces. I know, right? What do we? Oh no, I don't know. I don't. I've given up trying to question what their motives are. It's too boring. It's too boring and weird. But I'm just gonna say it again. There's a lot of screenshots. There's a lot of shit. That's all I'm gonna say. What a waste of time. Yeah. Anyway, we'll not talk about them anymore. Fuck them. Fuck them and the fence posts they wrote in on and the horseshoe they wrote in on. Anyway. Let's see. What else? Can't hear the music. Can you guys hear the music? Oh, it's not playing. What's this? Let's try this. Oh, we'll go to the next page. Do 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 do. Bump. Do 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 do. Ooh, I like that. Well, let's try this. I like this. Oh. In general, bad for mental hygiene to sympathize with psychotics without being locked up. I think I could listen to space. I don't know. I don't think you can, Siegfried. I don't think you can. And again, it's just like, I think it's just the initial FOMO of like, oh, I'm missing something, but I'm not really. Because here we are. You know what I mean? Well, I hope I don't sympathize with psychotics. Am I doing? I'm trying not to. Yeah, you can't do that. You can't check. You can get like a basic feed, but you can't get like you can't get the full experience. Yeah. It doesn't work like it used to. But I could just reactivate my account when I want to go back on. I'm just not ready to go back on because I'm trying to give Blue Sky a little bit of a chance too, frankly, because I mean, Twitter is going to die. I will have to reactivate my account because I want to download some of the media from my account that I may not have. Because some of the clips are pretty funny. Yeah. Sweet. All right, my darling lovies. I actually think I'm going to go ahead and end this stream so that you guys can get on Twitter. Twitter is 4chan. Twitter is 4chan. All the Watkins, I mean, Twitter is 4chan. Fred Brennan, Watkins, they're all Elmo's co-signing it. It's ridiculous. Anyway. Well, this has been so much fun. I hope you guys had a good time. I really do. I hope you enjoyed it. I was very excited to see the document come through. And yeah, totally. Got a boogie. Have a great Monday. And thank you. Oh, well, even the cat's leaving. Even the cat says, hell no. Hell no. Good. That's fine. We'll get some palm trees in for the last. But yeah, have a wonderful day, you guys. And again, I really do appreciate all of the coming in and participating and supporting and liking and sharing and all of the great support that you've given me as we make the twists and turns of the parasocial realms. I couldn't think of a better group of people to be friendly with and aligned with. So I'm really grateful. And haters can hate all they want, but they're never gonna have what we have. And that's just really sad. But whatever, you know what? If you come and say you're sorry, I might just forgive you. I'm that kind of person. I'm pretty damn fucking good at it. But you got to fucking say something, or else I assume that you're not on my side and that you would like to see me hurt. So take that for what you will. All right, everyone. Have a beautiful day and a great night. And I will probably see you. I don't know when I'll see you next. Not sure what any kind of like fun co-watching situation might be. Oh, I definitely will see members tomorrow night for movie night where we do Christmas Vacation and then probably Rare Exports, which is a Christmas horror Norwegian film, which is wonderful and hilarious. I might even start with that movie. But anyway, so for members, we will be doing that tomorrow night. It'll be on Discord, so plan accordingly. And then also we'll be doing another movie night for everybody. But I'll figure out when that can be. I'll try and I want to do some stuff during the holidays for the people that might just want some distraction during the holidays. So I'm going to try and think of a few times to go live if there's not necessarily something happening to give us an excuse to go live. So that is what we're going to do. So yeah, I need this. I love what I'm doing. And I really appreciate the camaraderie and smart, kind people. So that's really amazing. I will definitely post the link for it, Siegfried. And yeah, I'll post the link for the room and let's see what happens. Are you doing it from a phone or a browser? I just kind of wonder. I don't know. On the community, I will definitely post it on the members community page. Definitely, probably by tonight, if not sooner. And then we'll go there. Absolutely. Thank you. I mean, I'm just really grateful. I know the apps are kind of a pain in the ass. So the amount of like somersaults that you do in order to participate is really great. Yeah, the browser works. The phone doesn't work really well because it's a small screen, so it's hard to watch a movie on a small screen, but um hopefully we persevere through some of these, and maybe someday we get our own private Zoom room, which I would like to do, where that would be an easier way. Again, everything has its downsides, but we'll definitely keep trying to find the right solution. All right. Wow, what a day, what a morning. I really hope I hope it's good. I hope it's a nice day for everyone. And I will see you later. Have a good one.